May I please, Your Lordship? Lordship, I beg to mention item number 6, Lordship.
Hmm.
This matter may be, Lordship, taken up on 8/5/2024.
8-5.
8/5, Lordship. I have been instructed by N. Sharma, Lordship. Go ahead.
Right.
Deeply obliged.
Appellant.
Lordship,
Just a moment. You're the petitioner or the appellant?
appealant, Lordship.
Appellant will लिख दो.
Deeply obliged.
Just a moment. Have you taken consent from the other side? Have you taken consent from the other side?
No, Lordship. I'll inform the court.
Okay. All right. I don't have any objection, you know. With the consent of the other side, लिख दीजिए. Appellant with the consent of the other side.
May I, Your Lordship? Your Lordship, today the state and the respondents were to file reply, Your Lordship. For item number 1.
Yes, yes.
They,
May I please, Your Lordship?
What about item number 1? Yes.
the state and the private parties were to file reply, Your Lordship.
May I please, Lordship? Lordship, I'm for the respondent number 4,
Hmm.
and we have already filed the affidavit in position on last occasion.
Respond number 4. So the state has to file.
I'm for the state. This is writ appeal lawsuit.
Hmm. You want to file,
No.
so it's at the motion admission stage. So want to proceed? They are not willing to, they are not wishing to file.
Yes. Okay,
So you want to proceed, then we'll proceed.
Your Lordship, it may be fixed after 4 weeks for final hearing.
You are for the appellant.
Yes, applicant.
You
Other-
want to file.
No, Your Lordship, yes, they are, as
They are not willing to file
yes, then Your Lordship, it may be fixed after 4 weeks for final hearing.
for final hearing.
Then matter may be admitted and the matter may be fixed for hearing.
Can I admit it? No problem.
No.
Yes.
Objection.
No.
So then we'll admit it. You have a case, no? To admit it? Do you have a case to admit it? Let us see if you have a case for admission.
Your Lordship. And Your Lordship, the private respondents, they have filed only for one person, Your Lordship.
Hmm.
They,
It doesn't matter. It's up to them. It's good for you if they are not willing. Okay. You argue the matter, they should be admitted or not.
the conducting council is, Your Lordship, is on the way, Your Lordship.
We will wait or what? We'll wait or we will adjourn it. We'll
Then
adjourn it or we'll
matter will
wait
be taken up next week. No?
next week.
In admission.
After 4 weeks.
No issue.
hearing.
No issue anytime.
After 4 weeks, okay. As agreed by the learned counsel for both the sides. Raise the matter after 4 weeks. Okay. For release the matter for admission.
Admission.
Yes.
My lord, this is a contempt petition, my lord. The order, my lord, passed on 27/6/2022. That was again affirmed by the division bench of the Surabaya 6/9/2022. And since then, my lord, time granted was 6 months only. Now we are in the more than 2 years. So far, my lord, deputy commissioner is concerned. He has already, earlier deputy commissioner has already filed the affidavit saying that he doesn't have problem, provided the government releases the money, he is ready to distribute. So far, my lord, that is. So now the issue is that the government, why the government is not releasing the money? And it is more than 2 years, my lord, then My lord, petitioner is only that it's not unable to enjoy the fruits of the order of this honorable court, my lord. It's very unfortunate, my lord. They are only giving the lip service that they are having the full regard and they will comply, but action, my lord, I don't see, my lord.
Nine four, na? 9-4, sorry.
My lord, I am appearing for
And
number 1.
Oh, okay. I understand. That's right. Yeah, it starts from the other side. The discussion has been transferred. Okay. So they're delaying.
My lord, delay means, my lord, you see, this, I can only say that this is a deliberate only, my lord. Delay may be some reason, but if we see the conduct, my lord.
But they're willing to comply.
Repeatedly, my lord.
Yes, my
they have
lord,
taken time.
in fact, we are ready to comply and we are doing the needful action. And in this regard, Lordship, the problem what has arisen is that we have a prescribed rate for this land. That we have provided in our manual.
Hmm.
As per that manual,
Hmm.
for the urban area, the rate for this land is 700 only. Now,
So
Deputy Commissioner-
you do not have any dispute regarding the rate. Do you have any dispute regarding the rate?
No,
Only
ma'am.
compliance is necessary.
My lord, so far, here is the question, my lord. So far, rate has not been determined by this honorable court. This honorable court has said,
The rate will
you,
be as per
yes,
the-
whatever they want to, they have to just release the money.
Yes, that is what Lordship, we are this constant correspondence with the Deputy Commissioner. Lordship, may kindly peruse this
Let's allow them
Let-
some
let-
time. They are
let-
willing to comply.
letter issued to the
My
Deputy
lord,
Commissioner.
only,
Lordship.
I can only pray, my lord. The most, my lord can see. It's more than two years, my lord.
This is our latest communication made to the Deputy Commissioner also.
You have seen the 9-4 order, last order of this court.
Night for order.
Yes, 9-4-2024.
On that day also, Lordship, I have not seen the order, of course, but then on the.
It was passed in the presence, your presence.
Yes,
Then you were given 3 weeks time to take steps,
Yeah, well-
whatever you want to take
that is
for
what,
compliance.
yes, Lordship, that is what Lordship, we have.
Is
given-
another contempt, contempt after contempt.
My lord.
Lordship, only where we have a problem with the rate only, otherwise we are ready
We
to
don't
comply.
know, we don't
with
know.
the
It's a,
order of
it's
this
a,
honorable
it's a,
court.
it's a contempt proceedings, right?
We are very much eager to
If you
comply
don't
with
know
the
the
order
order
of
of
this
the,
honorable court.
if you don't read the order of the court, which was passed in your presence and only on the prayer made by you, what we can do?
My lord, that is exactly the.
'24. Thereafter, my lord, IA was filed by them saying that we need 6 months, but this honorable court said 6 months will be too much, given 3 months, my lord. That order, my lord, 2023, in the month of March, my lord. Now we are in the month of, my lord, May 2024, my lord. Whatever they want to pay, let them pay, my lord. That will be a different issue altogether, how much we are entitled for. That will be a different issue. That is not the issue in this case.
I am. That has to be determined first also. That is the exact problem also. We are ready to pay. Of course, we are not denying the.
So there
They should
existing,
be-
there are
they should
existing rates and there will be revised rates. Or rates have to be determined.
Also, we have this manual, where we have provided rate for each category. of-
Existing rates.
Yes.
The existing
Yes,
rates.
yes, Lord. So at the most, it will be 700 only.
Hmm.
Rest of the land, category of land are less than the 700, but we took 700.
Hmm.
Well, say, this is city clarification to deputy commissioner. As to why he has assessed the exorbitant rate. You have to go and buy this manual.
See, it's a problem between you and the deputy commissioner. Wrongly or rightly, relief has been granted to the petitioner.
Not denied the process. We are
If you are not denying, do it. You have been given 3 weeks time.
ready- Roshan, I have provided the.
Who is the authority under the Land Acquisition Act? Are you the authority?
Authority was with the.
Who is the authority?
State.
Notification has to be this issued by the.
It's okay. Who has to assess that? Who has to acquire the land? It is the collector. You have to abide by what the collector has said.
All right then. Yes, you are about to say.
Well, I
something.
am for the alleged contempt number 6, the deputy commissioner.
Ah.
I don't make much
You
of
are
the
for deputy
submission
commissioner.
because the contempt, once the petitioner bring it to the notice of the court or violation of certain court orders, it is between the court and the contemptors, my lord. So therefore, on this particular point, even I will request everybody not to make any submission. It is the court who will take a call, my lord. One. Number two, my lord,
Just wait.
They doesn't accept the decent. Whatever they have, they'll settle amongst themselves.
now, my lord, number two, as a deputy commissioner, I have done my duty. I have carried out the assessment in compliance of this honorable
Yes.
court. Then a small issue that has come up is because of the manual that land department has. They said ki the assessment made by the deputy commissioner is bit inflated and above
Yes.
the prescribed
I
rate.
just-
Yes, that
He has just submitted.
yeah, that is the difficulty. Now, my lord, I have been shifted out from there. From the,
Oh, that
now,
is-
a new deputy
that is
commissioner,
a tertiary dispute.
yeah,
The primary dispute.
the
has to
primary
be dealt with
dispute,
the contempt.
yes, sir. Primary
Contempt
dispute in this event, my lord, some more time is required for the state for the reasons that, my lord, model code of conduct is in force due to General Assembly and the Assembly elections. My lord. One, no government is there. At least except the,
Everything is over, no?
no,
Elections
no,
are
my
over.
lord. The model code of conduct is still in force and there is no government except the government headed by the chief minister as a caretaker government.
Sir, we are dealing this matter since last 2 years. We are not concerned about the MCC. We are not interested.
No, my
My
lord,
lord, law says, my lord.
Just wait. And much water has flown
no,
now.
my lord, kindly do not take it otherwise.
No,
I
no,
was
it's
assisting, my
not
lord.
that. It's
Otherwise,
not
I have
that.
nothing to make any
See,
submissions.
it's been nearly 2 years dealing with the matter.
Correct, my lord.
And who is stopping you to file? If you are angry, who is stopping you to approach the higher authority, higher court?
No, my lord, I am not.
No,
yeah,
no,
I
not,
was saying
not,
so.
not to you, all of you.
With
The
greatest
respondent,
respect.
alleged contemners.
Correct.
Today, we cannot take the, plea of election and all this. We're not concerned.
No, my lord, I
It's
agree.
something,
because if these are the kind words
it's
that is-
prima facie, it's a contempt.
that are falling from my lords, then the court has to decide. But as a court officer being duty bound, just I am assisting my lords that as of now, there is no government.
No, you have,
full-fledged
we're hearing you, we have heard you, but that's why we're,
Correct.
we're expressing our view.
Greatest respect, my lord.
That we cannot.
And petitioner has a full faith this court will definitely enforce the order against the contender, my lord. And my lord, so far my learned friend submission MCC part, so Apex Court has made it very clear. So far the order passed by the court, MCC will not have any effect. It has to be complied. The recent judgment, my lord. It has been made very clear, my lord. And we have a full hope.
Sir, we're conscious of all the thing, but then what is to be done is to, whether they should comply or not. We're on that.
My lord.
My lord, the compliance on my part, I have done it, my lord. It is the state government who has to take a call, my lord.
No,
Grateful.
that's what I'm saying. Is the respondent number 5?
Yes. It's up to him, Lordship. I am the requiring department, Lordship. Director Civil.
Which department?
Director Civil Aviation, requiring department. Unless they do
Requiring
the
department.
acquisition, I can't do anything.
Okay, then let us give him one date's time, only one date's time. He is willing to comply.
My lord,
please, but
then my
don't
lord,
mix those
then my lord,
issues.
then again, my lord, then specific time that may be recorded. Then within that time, it has to be. Now again, what will happen? This has been happening since last 2 years. Next, then they will come with different plea. After that, they will come a different plea. So this has been going since last 2 years.
We understand. It's undermining the order of the court.
This is very clear, my lord. Now,
No, don't raise a secondary issue like that higher rate has been fixed and all that.
Actually, you have been indicated last occasion. Whatever you want to do it, whether they accept it or not. What more indication can give this court can give to you? You do whatever, but pay it. You comply the court's order. That's all.
Now the person is without land.
my lord, this home and health, everything dismantled.
So he
Not
has,
getting money even. It's a pathetic situation.
so he has to look somewhere else for survival. Yes.
But now, I have recently submitting those, I'm submitting those things. The only the problem is that the rate, fixed by the commissioner is too high.
Mister, you cannot raise all these things before this court now in these proceedings. Why don't you understand? Try to understand.
This is too much. But since the.
By making the submission, it shows you are undermining the order of this court.
So there are other procedures. You'll have to refer to the, if you are not satisfied with the rate, then there are other procedures under the Land Acquisition Act. So now you cannot raise the issue here.
Return to the commissioner, please clarify. Okay, give us 3 more months.
So we'll pass an order. We'll give you 3 weeks time
Let it be.
to comply. And please don't raise those issues. I am repeating again over and over again that a higher rate has been fixed. You have a different forum for all those.
Correct.
And we are only limited to the contempt case.
Let us also make ID grant another 5 weeks.
Oh, no. You see that person is without anything for survival. And then he's staying in that way situation for 2 years.
In fact, the students have a greatest result for this honorable court also. Only the problem is that also it should not have been submitted in this way, but since process is we are not happening on MCC. But since the officers are again in this election decrease, so people I mean at least 5 weeks.
June 4 is the complement.
I think so. All right, then 4 weeks. 4 weeks time. All right,
You are the relief
My-
only.
my lord.
You are not interested in the punishment.
My lord,
Are you interested in punishment? Punishing them?
my lord, not at all, my lord. But definitely, my lord, one issue is there, not my interest of punishing them. Say, my lord, majesty
Yes,
of the law,
yes.
that is my interest.
That's why,
That is my interest.
that's why.
But the order of this honorable court, my lord,
It's
not-
okay.
But, Lordship, the government is only the approving, have only this, the power to approve the compensation.
yes,
Money has to come from this department.
Yes,
yeah,
yes.
Civil aviation department.
yes. Yeah.
Why don't you implement this deputy commissioner?
my
What's the
lord, I will do
problem?
in the meantime.
Whether will to make a difficult.
Immediately implemented it so that
Otherwise,
notice,
my lord-
notice can be issued.
My lord, otherwise, my lord, see from her, my lord, only the party clarified by the earlier deputies. Now, stain is that the moment money come, they are ready to give. Still, since last time prayer has been made, I will make the implement. But the issue is that money has to be released. That is the problem only.
Anyway,
Come from this civil aviation department.
Yes.
Lordship, unless acquisition is clear, Lordship, they are not giving us
Yes.
for red,
Oh.
Lordship. Till now, every time we
They're
move our
willing to
file
pay.
is given back, Lordship.
Only you have to clear all the hurdles. They are willing to pay. So then 4 weeks time.
So, 5 weeks, no, yes.
I don't know, after 5 weeks, then if you come with again another plea, then
And I am more afraid, my lord, this should not, otherwise will may set a precedent for other order also, that they will keep on doing in this way. I am not concerned about, because I know, my lord, definitely one day or other day I will get my money back.
yeah, yeah.
But not this, in this manner. Once they have not gone in appeal against the order of this honorable court, if they have any problem, they should have gone. Once order is there, they should voluntarily, without asking those things, should have complied by now.
So 4
And
weeks.
this court has
will be
been
stepping
very
into June.
liberal and
So
reasonable as well.
Over by June, na? Everything will be over by June. 4 weeks will be stepping into June.
After 4 June.
4 weeks, yes. After 4th June.
4.
That
And
will be
my
over 4 weeks.
Only my request, my lord, last chance, that may be, otherwise, I know, my lord, next time.
no,
next week-
we're making it clear. We'll grant them 4 weeks. On that day, on the next date, if they don't comply, we'll initiate contempt proceeding.
My lord. Deeply.
Last order was the 9th, no?
19.
Third, Mr. R. Sonar,
My lord.
learned counsel for the petitioner. Comma, Mr. T.T. Tara for
6.
respondent number 6, comma.
Lordship,
uh,
and for 1, 2, and 1, 2, and 7, Lordship.
comma, learned counsel Miss
G, Lordship.
G. Ette
Yes,
for respondent number 1, 2, and 7.
yes, Lordship.
I am for respondent.
Four को नहीं
And-
करेगा। 4 को नहीं करते।
3 and 5.
Just a moment. Let me know you are from which respondents. One, two, and
No, sir, I am for 3 and 5,
for 3 and 5.
yes.
Mr.
D come,
and D.
D come to.
Kamdu for respondent number 3 and 5. It is submitted on behalf of the petitioners that this case has been that the contenders have delayed, that the contenders have delayed, that that several adjournments have been taken by the respondent to comply with the order of this court to stop, while order dated 9/4/2024 Kamduk AMD UK. Three weeks' time was sought to verify the rates from the Deputy Commissioner Papum Pare. Full stop. The learned counsel for the respondent number 3 and 5 has sought 5 weeks' time today to comply the order of this court dated 9/4/2024 and make and proceed with the assessment for payment of compensation. It will be compensation, no? Compensation as per the existing rates, all right? All right?
No, kindly say that.
Compensation rate should you, belang na lage as per existing rates na lage. Proceed with the payment of compensation.
May kindly record in this way in terms of compensation manual. Because
These
No.
are not required,
No,
my
no,
lord.
no. This is not required. No, it
it
is not mentioned here in this order, 9/4. Then you will decide amongst yourselves. The land has been, the land was acquired by the petitioners, in which year? The land was
This
acquired,
was, matlab,
the land was acquired from the petitioners.
my lord. It was not exactly acquired. They, my lord, illegally demolished our structure.
Okay, okay.
Thereafter, this honorable directed
The
them
land was
acquired.
taken over, but
Yes,
taken
yes,
over
ma'am.
by the,
No,
peti-
eviction was there.
from the petitioners
Subsequent there.
in the year
Destruction, my lord, in the year 2022, my lord.
taken over, huh? There will be some tweaking and tinkering. I'll put in the appropriate words later,
Well.
yes. In which, that won't harm both sides.
My lord, dismantle, my lord.
Uh,
My house, it was dismantled in the year, my lord,
And the residences
2019.
and the property was, and the residences in the property was dismantled in the year 2009, 19, 2019. However, for the ends of justice, 4 weeks' time is accorded to the respondent number.
I'm taking
3 and 4.
weeks time.
Huh? How many weeks? 5 weeks' time. However, one final 5 weeks' time is accorded to the respondent. 5 weeks' time?
My lord, I have objection, my lord.
Yes, however, if one final 5 weeks' time is accorded to the respondent number, what respondent number? 3 and 5, to settle the matter of compensation.
And my lord, at least, my lord, thereafter, they should not come with any other plea, my lord.
Only
Seeking
one.
for a last chance,
Final,
my lord. Final, my lord.
Final, yes. Positively.
And
without
otherwise,
fail.
my lord, has observed, my lord, if failure to do so, then consequential contempt
yeah,
proceeding would be initiated.
Then on, positively without fail, failing which consequences will follow. Not consequences, failing which, adverse order may be passed. Or something else.
Failing with charge sheet.
Necessary order will
Charge
be
sheet will
taken,
be-
necessary steps will be taken.
Correct.
Necessary order will be passed, huh?
Appropriate orders will be passed accordingly.
Appropriate orders will be passed. Appropriate orders will be passed. Yeah,
Great.
thank you for helping me out, because I don't want to step into your arenas. You have so many formulas, then rates and everything. So once I step into those,
That is the difficulty.
the result will be we may end with some other result, unwanted results, which is not required.
Right.
Give this to me. একেলগে ৰেকৰ্ডৰ লগত দিবা দেই, বৰ্ডত নিদিবা। Yes,
Yes, Your Lordship, we have served the copies, extra copies to the respondents.
so you want to file affidavit in opposition?
Yes, my lord, I am representing respondent number 13 and
Yes,
14.
yes.
Your Honor, I pray this honorable court to give us 3 weeks time to file the affidavit.
Affidavit in opposition.
Yes,
This is.
Yeah. 15. No service. only.
Madam, we have received instructions for 4 to 7. And we are yet to receive instruction for 8 to 12.
8 to 12.
Yes, ma'am.
So only respondent number 15 is to appear.
well, I for the respondent number 1 and 1, 2, 3, madam. Have not received madam any instruction for the department.
Miss, yes, Miss
Sonam Somu. Sonam Somu.
Sonam Somo is, Miss S Somo is present on behalf of the petitioners. Mr. M Kato is present on behalf of
1, 2, and 3, madam.
respondent number 1, 2, and 3, comma. It is submitted that he is yet learned counsel, Mr. M Kato Lihibati. Learned senior counsel, no?
Yes, yes.
Or learned?
Deputy Solicitor.
Or deputy DSG, okay, the learned DSG is present on behalf of respondent number 1, 2, and 3, Mr.
N. Ratan for respondent number 4 to 12.
Additional Advocate General.
Additional Advocate General.
We have received instructions for 4 to 7.
Is present for respondent number 1, 2, and
No, 4 to 12.
4 to 12. And the learned additional Advocate General, double AG, has submitted that he has received instructions only from respondent number 4 to 12 and is
4 to 7.
4 to 7, and he has yet to receive instructions from the other respondents, Mr.
T. Omo
Tiomo
for 13 and 14.
is present for respondent number 13 and 14 and has prayed for time to file affidavit in objection. Steps to be taken to issue notice to respondent number 15.
Yes.
This is the matter. After how many weeks do you
3
want?
weeks.
This is the matter after 3 weeks.
It's not, the matter is not under investigation.
Yes.
It is under in this investigation and then charge sheet also has been filed.
What
It's
they,
as well.
Miss,
Yes, Your Lordship.
when the
Therefore-
investigation is there and the charge sheet has been filed, what is there?
Actually, we are seeking for the completion of road construction because it's been more than 16 years, it's not completed, so people are facing difficulties. So our concern is for the construction, not for the investigation more.
So why don't you,
But the prayer is made for re-investigation, my lord.
Yes,
That is the
that is there
so
also.
they are not interested. So why don't you settle the dispute, construct the road?
Yes, that is being carried out. Road
So then you
construction
give a
is,
report.
road construction is being carried out. That therefore,
Then
instruction for,
constructing, give a report, then next.
yes,
day
for,
maybe it will be
from
settled.
8 to 12, they are the appropriate authorities regarding the
From 8 to
stage.
12.
Yes, 8 to 12.
Can you give a report?
We'll ask,
Next
seek, we'll seek for the report,
Okay.
the
The,
progress of the work.
as the dispute is relating to road construction, as the matter is relating to road construction, a report is also sought. If, no, a report is sought now, as.
With regard to the progress of the work.
WG has submitted that road is being constructed and this dispute is solely on the construction of road. Which has not been disputed by the learned counsel for the petitioner. A report may be called for relating to the progress in the construction of the roads from which area? How many kilometers and?
It's 81 kilometers.
Huh?
81 kilometers.
81.
Sepa Chang Tajok Road. 81 kilometers.
Sepa to Siang Tajo, 81 kilometers.
CHAYAN.
TAJO.
NGTAGO.
JO,
JO. Two, Sepa to Sayan Tajo.
Lot.
81 kilometer,
881
81.
kilometers Miladi go to.
That will be after 3 weeks, ma'am.
4 weeks or 3 weeks kolo last?
4 weeks.
It was 3.
Will
4 weeks. Okay, all right, then 3 weeks then?
4 weeks. 4
4
weeks.
weeks.
Much obliged.
May it please, Your Lordship. But in this case, our PIL was directed against a non-completion of a road. And in fact, the respondent number 6 and 9 has already filed. But the important respondent will be respondent number 8, the border organization. In fact, we also want, this is a defense road in the border of Arunachal Pradesh and China. So if the deputy commissioner also gives a report regarding the present position, because the government's affidavit has supported our case.
Malad, I put the respondent number 1, 2, 3, 4, 8, 9, and 10, Malad. Malad, in respect of other respondent, Malad, I have not received any instructions from the Malad since the correspondence has already been made, Malad. Respondent number 9 has filed affidavit, Malad, saying that Malad, he is not the necessary party, Malad. So therefore, Malad, may I pray that Malad, the as per the Malad, the affidavit filed by the respondent number 9, Malad, name of the respondent number 9 may be Malad, the strike of Malad. He is not a necessary party in the
Malad, not at this stage. Malad, I'll object for the simple reason.
Malad,
The
only
respondent
the
number 8,
respondent
when
number
they
9.
file their affidavit, we will go. They need not
Yes.
be at this stage, let them file their affidavit. We'll take a call. At this
Have you
stage, your
furnished
lordship will
copies of
not
the
strike out
affidavit?
any
Malad,
points.
long days back, Malad, we have furnished the copy to them, Malad. Malad, respondent number 9 is the commanding officer, second in command, 8 Maratha Light Infantry, Malad. He is nothing to do with Malad, all this project work. Malad, he is, Malad, this of commanding officer is posted at that.
It's okay, we'll see that. You file on behalf of 8 and 10 in that
Yes.
case?
Malad, basically, this, there has to be filed by the respondent, correctly, Malad, the respondent 8, 9, sorry, 8, 10, and 3 is the Malad, the main, Malad.
You file on behalf of
Yes,
them.
yes.
So
We take up
therefore,
the matter after you file the affidavit. Yes.
Malad, this is the since
He
the
has raised
affidavit has been filed
objection.
by the respondent
Let him-
number 9.
Let him submit his objection.
Malad.
Meanwhile, he's raised objection not at this moment. So the learned counsel, you are for the petitioner. PIL.
For
Yes,
striking off, you have to
So-
file a IA, not affidavit.
Absolutely, absolutely. In fact, one thing I like to pray, since the
Just
matter
for a moment,
relates
may I
to
take your lordships to the
It's
affidavit?
okay, we'll consider the next step.
Madam.
You file an appropriate
Yes, yes,
application.
yes.
In
But then
paragraph
you are,
8
since
of-
you are
of-
representing respondent 8 and 10, who is the main respondent, you file an affidavit, that's all.
Malad.
And in fact, in respondent number 6, the deputy commissioner, he, in pursuant to this court's order, he has filed an affidavit supporting our case. My lord, can he give a status report regarding it? Because our entire case is that it's a defense road, operational importance is there, defense of the country is involved. They want to divert it to another place. So he let us give a status report like the item number 3 as regards the present position. Whether
My
the
lord, I am for the deputy commissioner, my lord. I don't know what sort of status. My lord, alignment, realignment, it is between the, my lord, the executing agency, because this depends, my lord, strategy, my lord. My lord, here the district administration nothing to do, my lord. Now, my friend is asking that we should file a status report, whether alignment should be done or not. My lord, we have nothing to do that.
No, no,
It's
I am
up to
not
the-
saying, but first he should remember
Then what sort
I
of
have
status
said.
you are asking for?
I have
asking us to
not
file
said about the
affidavit?
realignment. What is the present position? It's my case, I can always ask for it.
No, present
In
position,
fact,
like
there
there is a
are,
dispute
my lord,
between
if
the
he is
village and
insisting,
my lord.
I can place some Supreme Court
But
judgments.
someone
on
is
the
asking,
point
my lord,
also.
the division from the DPR, someone asking, my lord, original DPR should be
Okay,
maintained, my lord.
let them file
It's
their
up to
affidavit
the
first.
central agency, my lord.
Construction is going on,
I'm sorry, my lord.
construction under process, it's in progress. Construction,
Construction, there, okay, I don't think so.
no construction.
Preliminary, Malad, there is
So
the-
this PIL is filed by, this is a
My lord,
PIL, isn't it?
PL, my
Yes,
lord.
my
There
lord,
is some
it's a-
PIL is filed by
A
Impalo
resident.
Mena
Yes, a resident of that area, border area.
Okay, he's a resident,
Resident,
as a resident.
have some partial interest, resident.
Well, that is a submission made by respondent throughout India. It doesn't matter. The
Bona
concept of
fide.
PIL has gone ahead of them. Well, we cannot take a doctrinal view here.
So you have to have a locus standi also to file the PIL.
Yes,
So
my
that
lord.
is why,
Yes.
this is the reason why I'm asking.
Yes, my
Uh,
lord, we will sufficiently answer that query because
Uh.
notices are gone. Once it comes up for admission, and we are ready for it.
Okay.
At this stage, lordship, let the respondent file their counter.
Yes. Affidavits are yet to be filed, so please file the affidavits and let's proceed. Not yet submitted, affidavits in reply not yet submitted. Learned
For the
counsel,
past
Mr.
6 months. DK
The past
Das.
six- Learned counsel, Mr. DK Das
Yes, lordship.
is present on behalf of the petitioners. You you will be more helpful because I've forgotten all the names. I have come after 5 months, I think. I've come after 5 or 6 months. I again forgot all your names.
My lord,
Mr.
I,
M. Kato, huh?
yes, I'm correct.
M. Kato, DSGI is present on behalf of respondent number. Which respondents?
1 to 4 and 8, 9, 10.
1 to 4 and 8, 9, 10 and learned counsel, learned government advocate
My lord, I,
Additional,
additional advocate general, my lord.
and
Arits
learned
Nabam.
double AG, Mr.
Arits Nabam.
RH
Arits Nabam.
RH.
Nabam is present on behalf of the respondent
My lord,
number
respondent 5 to 7, my lord.
5 to 7. The learned counsel for the respondents have submitted for time to file the affidavit in opposition. List the matter when
My lord,
After 4 weeks.
after 4 weeks, all right? After 4
My
weeks.
lord, I have some difficulty. Can it be after 10th of June? I'll be out of station.
You want a
Okay.
date?
Yes, lordship. Because
we gi-
since
since
yes.
my lord maintenance has followed your lordship, my lord, can that be, issue be kept open, my lord?
Maintainability.
Yes, ma'am.
But he has submitted that notices
My
have been
lord.
issued.
Doesn't matter, man. That can be raised any
My
time.
lord, your
Be-
lordship
before
did not
disposal, that
reflect
can
it.
be raised.
You'll
On the
raise it
next
later.
day, we will check.
Next, on next day, everything will be relating
Yes,
to
Everything.
checking out their names also.
Yes.
All right. After 4 weeks,
My
or you want a date?
Yes, lordship, if your
So we
lordship
can give him
it.
a date.
My lord,
I think he-
since
After
my friend
10th.
from outside, my lord, let him choose the date, my lord.
My lord,
After
can
10th
it be on the 13th of,
That 13th of June,
Yeah.
yes,
June, all right.
obliged.
My lord, before my friend says something, my lord, this is also my lord,
Amended.
amended
Already
recruitment rule, my lord.
Already amended.
Not yet, my lord, because again, it has to be reintroduced in the cabinet, my lord, since my lord, election procedure will be over by only somewhere in 4th June, my lord.
Yeah.
Can be after 4th June, my lord, so
Sir,
that let there be new formation of government, my lord, so that again, that issue can be placed before the cabinet, my lord.
Sir, there is judgment recently on this,
My-
all these grounds.
I'm aware of that, my lord, that's why I place my difficulties, my lord.
No,
And-
no MCC, no election, no grounds
But-
of all these elections.
Yeah.
But there has to be
It came out-
cabinet, my lord, to take a call, my
It came
lord,
out recently.
my lord. But without any cabinet, my lord,
I understand.
there cannot be a final call for that, my lord. That's why.
It's also since two years.
No,
Wait,
my lord, 2019, this matter was heard. At that point of time, a submission was made, it is under consideration.
Yes,
I mean,
it-
2019.
But it happens. How,
But it was under process, my lord. And it-
how this
I-
this
in fact-
system works.
I was lucky, my lord, this honorable court wanted to close the matter. I had so impressed, so I prayed that no, let it be kept pending so that we'll see what they do. I was lucky in that sense.
But today he's also very positive
For 5
that he's
years.
amending. It's
Well-
for the cabinet.
It has to be placed again.
In that case, to
All right then, we'll list it.
My lord,
After the new government,
my lord,
formation of the new government.
can it be, my lord, July, first week of July, any date, first week,
July?
July, my lord. Because fourth, my
Yes,
lord,
yes, I understand.
process will be completed, there will be formation of government and, yes, my lord.
Sure, because they are amending. only.
Yes, and there is there is interim order also, my lord.
July.
Well, I
Interim
waited
order
5
also.
years.
All right.
Deep
Uh,
Panging for petition.
Learned Counsel, Mr. D. Panging for the petitioner, hard লিখি দিয়া। তাৰপিছতে
R.H. Ravun, learned additional advocate.
RS Navum Learned double AG for the respondent number.
My lord, I'm for respondent number. Sorry.
Let me help you.
My lord, 1 to 4, my lord.
1 to 4. And Mr.
C Modi.
C Modi for respond number 5.
Five.
As agreed by the learned counsel for both the sides, list the matter on
My lord, first week of July, my lord.
the
First
first.
week of July, my lord, there is a vacation, my lord. Then can it be somewhere 16, 17, any date, my lord? No issue.
Vacation will be over by 18th, I think.
17th of July, ma'am.
17th of July.
17 of July, my lord, yes.
List the matter on 17th of July.
My lord.
Public.
Of like.
Yeah, please.
Mm.
So if here I have a prayer for adjournment. Learned AG is appearing in this case for estate. Today, he could not appear. On 17, he is coming. So if matter can be fixed on 17,
What is there? You pay.
Hearing?
Up.
Hearing matter?
close. Hearing matter.
He's seeking for a time.
I understand. You can submit.
Actually, brief was with him only.
Okay.
So on
All right.
17 is today is 6 only. After
All right, you have
after 10 days.
You are expecting some miracle on 17.
Yes.
Learned
Do
AG
you-
is coming.
Do you have any objection?
occasion, let's say it was supposed to this.
Yes, yes. But he doesn't have the brief. But he doesn't have the brief. So
Let us have the privilege of hearing the AG.
No, sir.
learned
on
counsel
17th.
for the, you are the appellant, no? Learned
I'm
counsel for the
correct.
appellant, Mr.
S. Tapin, senior government advocate.
S. Tapin, senior.
S. Tapin has prayed for adjournment with the consent of the other side leader. Okay, has prayed for adjournment, leaves the matter, when do you want?
17th of this month.
Leaves the matter on this month, 17/5.
It's better not to list it on 17.
No, sir.
Yes.
I have taken consent from the other side also.
Okay then, learned counsel for the petitioner, Mr.
O Modi.
O Modi,
Yes, ma'am.
with the consent of the side has prayed for adjournment, leaves the matter, when do you want?
After 4 weeks.
After 4 weeks.
May I?
Hmm.
My leadership, I beg to mention item number 49.
Hmm.
My senior council couldn't make it due to some personal difficulties. So kindly list this matter after 2 weeks. The consent from other party has been taken out.
Learned counsel, Mr.
MUA,
Ube on behalf of learned counsel, Mr.
SK theory.
SK Dury has prayed for adjournment. Have you taken the consent of the other side?
Yes, your
Mazat,
my leadership.
with the consent, you include in between somewhere, with the consent of the other side, has prayed for adjournment, list the matter after?
Ma'am, is it possible to fix on 21st May?
Yes,
Okay, 21st May.
21st May.
Okay. Deeply obliged. May I please, Lordship? I beg to mention item number 48, 48. Lordship.
48 or 49?
48.
Oh, just now it was 49.
49, yes.
48.
Yeah, on behalf of Jungam Jini, J. Jini, Your Lordship.
Learned counsel, Mr.
T. Tarin,
T.
Tarin, Tarin,
T. T. Tarin, on
Yes.
behalf of learned counsel, Mr. J. G.
Jenny, your lordship.
has prayed for adjourn, with the consent of the other side,
Yes, your lordship.
comma, with the consent of the other side has
After
prayed
3 weeks.
for adjournment, list the matter after 3 weeks.
Yes, lordship. Obliged. Lordship, I beg to mention item number 3, 6 and 23. On behalf of L. Verme, Standing Counsel for Power Department,
3,
6 and 23.
3, 6 and 23.
Yes,
Have you taken consent from the other side?
yes,
3, 6,
23.
you are for the respondent,
Yes,
and 20,
23.
learned counsel, Mr. Your name?
S. Yirang, on behalf of L. Verme.
S.
Yirang,
On behalf of learned counsel, Mr. L. Parme, comma, with the consent of the other side has prayed for adjournment, list the matter when you want,
3 weeks, lordship.
after 3 weeks.
And lordship, item number 12 also.
12 also,
Yes,
same order,
yes,
12 is same order.
Yes, same order,
12
Lordship.
same order.
I know.
My pleasure. I will mention item number 4 for adjournment here.
4,
Yes.
what about 4?
Leaving,
Adjournment,
yes, adjournment.
taken consent,
Yes.
learned counsel, Mr.
L Kagong,
L. Tabong.
Kagong,
L.
K.
Kagong, with the
Yeah.
consent of the other side has prayed for adjournment, list the matter when, after
After 3 weeks
3 weeks.
of life.
Your Honor,
Hmm.
I'd like to mention item number 16 and 18 on behalf of Standing Counsel Babatagum, Education Department.
Learned counsel, Mr. Your good name,
H. Thai,
with the on behalf of
Titagum, Standing Counsel for Education Department,
standing counsel, Mr.
Titagum,
Standing counsel for education.
Education
Standing
Department.
counsel, comma, education has
Department.
prayed for adjournment with the consent, comma, with the consent of the other side
Yes, Your Honor.
has prayed for adjournment, list the matter when you are,
4 weeks, Your Honor.
after 4 weeks.
Obliged.
May I please,
Hmm.
I will to mention item number 47. ma'am.
47.
Yes, ma'am. Then can consent from other side also. Okay? Now, I need to file reply to the affidavit in opposition filed by the state respondent.
Here for the
Petitioner,
petitioner, affidavit in reply
filed by the affidavit in opposition, filed by the,
against the affidavit in opposition.
yes, ma'am. 2 weeks time. I will give.
Learned counsel, Mr. H. Lampu,
Yes, ma'am.
has prayed for 2 weeks' time to submit affidavit in reply against the affidavit in opposition. Learned government advocate is present. Your name, good name?
Wairiram, Your Lordship.
List the matter after how many, 2 weeks' time?
2 weeks time. ma'am.
List the matter after 2 weeks.
My lord, the interim order is there. ma'am.
Interim order shall remain in force till then.
Obliged.
My lordship.
Hmm.
Lordship, I would like to mention item number 13, lordship.
32.
13(1)(3), lordship.
Okay.
Lordship, I have to file rejoinder affidavit. lordship.
Rejoinder affidavit.
Yes, lordship. 2 weeks time may be given, lordship. I have taken the consent from the other side.
Learned counsel, Mr.
Elba.
Ma'am, I'm representing that
L.
APU in this matter, ma'am.
13.
Oh, yours is 13. Okay, sorry.
Elba, lordship.
El Bamu.
Petitioner.
El Bamu has prayed for 2 weeks' time to file
Rejoinder.
rejoinder affidavit. You are for?
It was 31.
With the, include this, with the consent of the side. List the matter, list accordingly, 2 weeks' time.
After
no?
2
We have
weeks.
sought 2 weeks' time.
Okay. Lordship, I beg to
Yes.
mention item number 30. I am for the private respondent number 4. This morning I filed my affidavit in opposition. And I'm also representing the respondent number 3. And the respondent number 3 will not file the affidavit in opposition. Therefore, this matter may be released after 3 weeks for admission hearing.
Item number 30. Did you see the file? Item number 30. Learned Counsel, Mr.
X Gatti. X Gatti.
X Gyati for respondent number 3.
3 and 4.
3 and 4 has submitted that he has filed affidavit,
Respondent number 4, I have 5.
that he has filed affidavit
Yes, this morning.
on behalf of respondent number 4 and respondent number 3.
Will rely the affidavit
will
filed by 2 and 4.
rely on the affidavit filed by
and
respondent
4.
number 2 and 4. So this matter can be listed. for
Admission prior, admission.
that everything is complete.
Yes,
Pleadings are complete.
yes.
As pleadings are complete, stop as pleadings are complete. This is a matter for admission hearing.
After
For
3 weeks.
admission.
Yes.
This is a matter for admission after 3 weeks.
Okay.
Just a moment, just a minute.
I beg to mention item number 20, my lord. 20, item number 20, I beg for adjournment, my lord.
Item number
2020. And here government has to file affidavit, my lord.
yes,
Government has to file affidavit. my lord.
you have prayed for adjournment.
Yes, my lord.
Okay, then petitioner adjournment. The learned government advocate, Likho, learned government advocate. Has to file affidavit, is to file affidavit, will file.
Yes,
Will file affidavit. In opposition,
yes, your lord.
this is the matter after how many weeks?
3 weeks, your lord.
3 weeks.
My lord, there is interim order, my lord.
Interim order shall remain in force till then.
Hold it, my lord.
May I please, madam? My lord, I beg to mention item number 28, ma'am. I am for the respondent on behalf of K. Lowland, ma'am. Matter may be
Okay.
K. Lowland, ma'am.
I'm for the petitioner.
Petitioner.
In fact, my lord, the item number 25 to 20 is 29, my lord, connected matter.
25 to 29.
Yes, my lord.
These are connected matters.
So you are for the respondent, you are for the
Petitioner
petitioner.
in item number 28.
So he's seeking adjournment. Do you have any objection?
No, no.
Okay. 25 to 29. 25, 26. Learned Counsel, Mr.
M. Doji, my lord.
M. Doji for the respondent with the consent of the other side has prayed for adjournment. What is your name?
K. Loya.
Learned Counsel, Mr. K. Loy is present on behalf of the petitioner. List the matter when you want.
After 4 weeks, my lord.
List the matter after 4 weeks.
So, see, interim order is there, Lord.
Interim order. In all the matters from 25 to 29,
Rest of the item, I have no idea, Lord. See, in item 28,
only item number 28, huh?
interim order is there. Lord.
Interim order shall remain in force till then. Only item number 28. All right.
Obliged.
Highly obliged.
Lordship, item number 38. 38.
38, okay, yes, Lordship.
I'm for the petitioner, Your Lordship. I'm for the petitioner here. And senior counsel is not well, so he's in the hospital.
Miss, yes, your good name, please. Huh?
Waipang.
Waifamu. Has submitted that learned counsel who is not well.
She tapak.
T Tapak, learned counsel, Mr. T Tapak is not, learned counsel for the petitioner, Mr. T Tapak is not well. List the matter. When do you want?
After 3 weeks.
Learned government advocate, you are representing the government in this case? Okay, learned government advocate, Miss, is present.
Lordship, as I said, my senior is not well.
Same order, same order.
Matter may be postponed for tomorrow, Lordship. It's a motion matter. Item number 1.
Same order. List the matter, data tomorrow is 7th, huh? List the matter on 7th.
May I please, my lord. My lord, this matter is pertaining to pension. I have superannuated in the 31st August 2023. The respondent authority is not processing my pension documents on the ground that probably NOC was not issued by the Deputy Commissioner. Annex 1, my lord, phase 21 is order which shows my superannuation retirement. May I read, my lord?
Just a moment.
Phase 21.
Yes,
21.
yes, yes.
On attaining the age of superannuation of 60 years as a date of birth being such and such, Sri Victor Landi LO under the establishment of district research officer, 0 will retire from government service with effect from 31st August 2023 end. And before my retirement, my lord, I have already vacated government quarter, etc., which is at Annex 3 phase 23, by which I have informed the Deputy Commissioner that I have vacated my government quarter.
Where, page,
Page 23.
page 23.
Yes, Annex 3.
Yes,
And thereafter, I sought NOC from the Deputy Commissioner so that my pension paper could be processed, which is page 29. And same was forwarded by the district research officer, which is phase 30.
for NOC.
NOC.
Page 29 for NOC. is for-
Yes.
Um,
So it appears a respondent authority earlier issued one standing order by which NOC from the concerned Deputy Commissioner is necessary in case of promotion, retirement, etc., which is Annex 4 and Annex 5.
Page,
Phase 24.
page 24,
24 and the last paragraph.
last paragraph.
Yes. Last paragraph. To curb this practice of encroachment and demolition, illegal use of public property, it has been decided that the vigilance clearance to government official for promotion and for settling retirement dues, NOC shall be obtained from the concerned Deputy Commissioner, clearly stating the government official has not encroached upon any government property, nor has caused any damage or abated encroachment on the public property by the private person. And a similar order was issued by Commissioner Vigilance, which is phase 25. So in this case, my lord, though I have submitted application representation for issuance of NOC, but same has not been responded by the Deputy Commissioner. Neither issued any NOC nor replied anything.
This page 25 is relating to the modification of the earlier order.
Earlier order.
Okay.
Okay. In a similar matter, this honorable court has repeatedly directed the respondent authority to process the pension documents, etc., without requiring my lord, this NOC from the Deputy Commissioner.
Yes, of course.
So
No
earlier,
other department has NOC problems.
yes.
Yes.
So I
What you
have
to say?
Your Lordship may dispose this,
Hmm?
dispose this matter.
I can dispose it.
Yes, your Lordship, with a direction to the concerned department,
yes,
authorities to issue NOC.
To issue NOC. I'll dispose it then.
yes, it can dispose with issue NOC and to process my
You
pension.
issue, you'll have to give me your word, or at least you'll have to give some valid submission so that I can dispose it, or I'll fix it for another date.
No, your Lordship, this
Huh.
court, honorable court has already,
It's covered case.
yes, covered
Yes, in
case.
many cases on the motion stage of
You have
disposal.
any order?
I have annex
It has been
8, 9,
annexed in the-
10,
Annexure 8, 9 and 10.
10
Yes,
years.
your
Give me the pages.
Page starting from page 31.
Page, starting from page 31,
Yes.
earlier orders.
Yes, earlier honor. This is in case of one Ganesh Koyu. And then again, page 36 in case of one Nyamba Songmu. And again in phase 41, here in the way of interim or respondent authority was directed to process the pension document.
Oh, there, from page 34 onwards.
31 onwards.
And page 41 is?
41 is also another order from this honorable court.
Okay.
And page 36 is also another judgment order from this honorable court.
All right. Heard, Mr.
D. Last.
For the petitioner, what is the petitioner's name? Victor Landi.
Victor Landi.
Sri Victor Landi. And Mr.
Y Riram, Your Lordship.
Sorry?
Y
Lamu, no?
Y Riram.
Item number,
2, Your Lordship.
government advocate,
Yes, Your Lordship.
Arunachal Pradesh. The petitioner has filed this application. Under Article 226 of the Constitution of India for a writ in the nature of writ of certiorari, mandamus or any other appropriate writ. Directing the respondent authorities to issue no objection certificate, stroke vigilance clearance to the petitioner to apply for pensionary and other gratuity benefits due to him on superannuation. It is submitted on behalf of the petitioner that filed order dated 10/7/2023, the petitioner had retired from government service. No, Bhai order dated, no, the Bhai, just check out Bhai order dated. The petitioner cut off Bhai order dated. The petitioner had retired from government service with effect from 31/8/2023. After attaining 60 years. After completing 60 years. After completion of after 60 years, after 60 years, stop. The order dated 10/7/2023, more particularly annexure 1 of the petition, reflects the order of superannuation of the petitioner. The petitioner then thereafter sought for no objection certificate from the deputy commissioner.
Yes.
To his letter dated 9/6/2023. Full stop. It is submitted by on behalf of the petitioner as well as on behalf of the respondents that that by standing order dated 2/4/2013
Yes, ma'am.
being that by standing order dated by order number, or is it a memo number or order number? It must be a government memo
yes,
number,
Yes.
OM number.
Yes, below, in the bottom it's given memo, but in the above it's given order.
By memo number PSH -06 stroke 2012-13 stroke 97 dated Itanagar 2/4/2013, the procedure to obtain an NOC is, or procedure to obtain the retirement benefits by an incumbent is to obtain an NOC from the government,
Concerned Deputy Commissioner.
from the concerned deputy commissioner, from the concerned deputy commissioner. The order is annexed as memo, annexure number 4 of the petition. And the annexure number 5 of the petition is the modified order.
Modified order.
Modified order. It is also submitted at the bar that several orders have been passed by this court in WPC number 476 within bracket AP 2016, comma, WPC number 476. I've already stated, no? Comma. WPC number 294 AP 2018. And WPC number 301 of 2021, wherein this court has directed the government to immediately process the pension papers of the incumbents after retirement without insisting for the petitioners for any no objection certificate in terms of the order dated 2/4/2013 issued by the principal secretary within bracket bridge bracket close VIG, Government of Arunachal Pradesh, Itanagar, with memo number PSH -06 stroke 2012-13 stroke 97, as well as in terms of the order dated 25/2/2020 issued by the commissioner within bracket bridge bracket close Government of Arunachal Pradesh, Itanagar, by memo number VIG-71 stroke 2014 stroke 365. The learned government advocate,
Yes, sir.
the learned government advocate has also submitted that without insisting on no objection certificate, the petitioner's submission for the benefit for the retirement benefits will be considered. The learned counsel for the petitioner has submitted that the petitioner has that the petitioner is awaiting for no objection certificate.
Yes.
Petitioner has been waiting for the no objection certificate, but as he has not received any no objection from the Deputy Commissioner, he is unable to bear the fruits of the of his retirement benefits, and benefits full stop. The petitioner, considering in view of my foregoing discussions, this petition is disposed of with a direction,
Yes.
to the respondent authority, to the respondents, to consider the petitioner's prayer for the retirement benefits without insisting on no objection certificate, as captioned above. No objection certificates as
Allow
mentioned.
some time frame may be given.
Within how many?
2 months, Your Lordship. 30 days, earlier judgment, 30 days given all the judgment.
Within 30 days.
Most of it.
I'm sorry, my lord. We are in item number 3.
Item number 3 has, I think, been wrongly mentioned, madam.
I think so.
My lord, we are waiting for the my lord.
I appear for item number 3, madam. You have not mentioned the matter.
It was mentioned.
No, my
No,
lord,
we did
not,
not
no
mention.
mention. Maybe wrongly, my lord.
Item no, just cut off the order, only 2 lines out of. We can cut it up.
My lord. So
Because-
therefore, my lord, item number 3 may be called for, my lord.
Yes, we'll call item number 3. You cut out that order, stack of that order, item number 3. Please pass it over for the moment. I think the record has gone to the registry. Pass just for.
Call it after some time.
For the time being, yes.
My lord, I am for the petitioner, my lord.
Hmm.
My lord, I need some more time to file affidavit in reply, my lord.
Affidavit in reply.
Yes,
You
madam.
have filed affidavit in objection.
Yes, Your Lordship, we have filed
Opposition.
already.
Learned counsel, Mr. Mr.
M. Doji, my lord.
M.
M. Doji, my lord.
Doji has prayed for, with the consent of the other side, has prayed for time to file affidavit in
Affidavit in reply.
Affidavit in reply. List the matter after
Well, 3 weeks, my lord.
3 weeks.
Obliged.
My lord, in the meantime, my lord, there is an interim order. It may be continued.
Interim order shall remain in force till then.
Obliged.
May it please Your Lordship.
Mm.
My lords, the matter pertains to a tender. The petitioner before your lordship, he has challenged his rejection, which is patently illegal, and also the order whereby the tender has been retendered, my lords. The work has been retendered. Now, my lords, before I urge the points, my lords, urge the grounds, I would very briefly like to narrate the facts, my lord, the antecedent facts, my lord. My lord, the Ministry of Power, Government of India, under a scheme, had, my lords, a scheme was formulated, and as per the scheme, the government of Arunachal Pradesh, which is the implementing agency, had issued a notice inviting tender on 28/07/2023, my lords. The notice inviting tender was issued on 28/7/2023. Along with the tender, there was the standard bidding document, in short, which is SBD, my lords. Now, insofar as the SBD is concerned, that governs the entire tender, how the tender would be allotted to someone, how the work would be granted, my lords. Now, pursuant to the NIT, the petitioner being qualified, he participated in the tender process, my lords, along with 10 other participants, my lords. Now, the tender itself is a 2-stage tender, my lords. The first is the technical bid, thereafter the financial bid, my lords. So, in the technical bid, the petitioner, along with 2 other parties, my lords, 2 other contractors, they qualified, my lords, in the technical bid. The other 2 parties are respondent number 6 and 7, my lords. Thereafter, when the financial bid was opened, my lords, the petitioner had quoted an amount of 28 crores odd, my lords.
which was the lowest bidder, the L1 bid, my
In
lord.
that price bid, financial bid, he has
Financial.
quoted the lowest.
Lowest.
He is the lowest bidder.
Lowest bidder, and whereas the respondent number 6 has quoted 1 crore more, 29 crores odd, my lords. I am not troubling your lordships with the entire numbers, my lords. And the respondent number 7 had quoted an amount of 36 crores. Now, my lords, the tender amount,
So 1 crore less than the technical petitioner.
the respondent number 6 has quoted 1 crore more than the petitioner,
And
and
number 7.
the respondent number 7 has quoted around 8 crores more than the petitioner, who's the lowest bidder. Now, my lords,
So how much did the petitioner quote?
I'll give the exact amount, my lords. It's 283807,902.
Okay.
So, my lords, we emerged as the lowest bidder, my lords, L1 bidder. Now, my lords, the tender had a base price, my lords. The estimated cost of the tender was around 34 crores 94 lakhs. That was the base price. And the petitioner had admittedly quoted some 18% below the base price. And the respondent number 6, 17% below the base price. And the respondent number 7, plus 1% above the base price. Plus 5%, I'm so sorry, my lords. Now, pursuant thereto, my lords, we received a letter from the tendering authority saying that our rate was an abnormal rate. And therefore, we were asked to show cause. Now, when we were asked to show cause, in the show cause, the tendering authority had stated that our rate is in violation of a clause of a tender, the standard bidding document, clause 38, and also a 2017 Government of India guidelines, some guidelines. my lords. So we replied that it's not abnormal. Thereafter, my lords, our bids stood rejected. So once the bids stood rejected, my lords, we approached this honorable court and filed a writ petition. My lords. That writ petition is writ petition 76 of 24, which is still pending. Now, when the matter was pending, the court was in session of the matter. The tendering authority had proceeded with a re-evaluation, my lords. Re-evaluation of the tender, and as per the re-evaluation, they first recommended the respondent number 7, who had quoted, like I said, my lords, 5% above the estimated price and who was the third lowest bidder. So the tendering authority had recommended his name.
So they went for re-evaluation.
They evaluated and they said no, because my tender according to them was abnormally low. They did not choose respondent, the other lowest bidder, but they chose the third lowest bidder who had quoted 5% above, my lords.
So they chose that tender
Third
number
item.
7.
And my lords, most important fact, my lords, they did that when the court was in session of the matter. Court was already in
But
session of.
stay was not granted.
There's
to
no
you.
stay, but court was nonetheless, my lords. Court was in session of the matter, and court was, so just to make the matter infructuous or some other vested reasons, my lords. So they had reevaluated and they said the R7 is liable to get the contract. Now the matter does not stop there, my lords. So thereafter, my lords, when
So R7 was offered. the tender.
recommended, but he was not, no work order was issued. Now thereafter, my lords, there was a second re-evaluation, my lords. My lord would also look at the conduct, because I'll be harping on malice in law and malice in fact, my lords. So that can be only, my lords, seen from the attending facts and circumstances, my lords. So after the R7 was initially recommended, for reasons best known to the authorities, they again evaluate the tender. And this time, they say, no, we are not giving it to the R7, we're giving it to R6, who is the second lowest bidder, my lords. Thereafter, my lords, when there was the tussle that, these decisions, my lords, they're not based on any reasons, my lords. Thereafter, the present challenge, my lords, when matters remain as, my lords, the government of Arunachal Pradesh had issued a letter, my lords. That letter is 240324 to the superintending engineer, saying that there is something fishy with your tender process. You're first awarding it to respondent number 7, then to respondent number 6. You're rejecting the lowest bid. So there is something fishy with the tender, and you go for retendering. Now, the present application has been filed against the order whereby retender has been directed, because clearly my right.
So this tender is relating to what?
My tender, my lords, it's a
What type of work?
name of the work is, my lords, development of distribution infrastructure in Upper Suban. So far what I've understood, my lords, it relates to power. It's a bit complex, my lords. It's a power under the Ministry of Power, and it relates to distribution of power, my lords, in the Upper Subansiri district, my lords. Now, my lords, the first ground of challenge, my lords, when the court was in session of the matter, the administrative authority ought not to have taken a decision and ought to have, well, they should have awaited the outcome of the writ petition matter. The only reason for doing that is to make the writ petition infructuous. Now, on that point, my lord, I'll just place one paragraph of the judgment, my lord. I'll come to the other point. It clearly says, my lord, kindly give me a moment. My lord, it reported in 2014 4 GLR page 3, my lord. 14 4 GLR page 3. I'm reading paragraph 15, my lord. Well, I'm very sorry, I don't have a copy, my lord. I'll read it very slowly. if it's
We'll
okay.
get it. Get me a copy. 2014 4 GLR, para
Page
3.
3.
You can start reading.
I'll very slowly read it, my lord. It was. लिखी doesn't? Then so. My lord, 15, paragraph 15, it says, my lord, when the court is in session of a matter, an administrative authority cannot start a parallel proceeding on the very same subject matter at its own ipse dixit and record a finding on the issues. If such an action is taken, the same will amount to directly interfering with the dispensation of justice by the courts of law. We have no hesitation to hold that the Assistant Registrar of Cooperative Societies, Hujai, clearly transgressed his authority in venturing into dabble in a matter which is sub judice before this court. Clearly, this is an instance of an authority trying to overreach the orders of this court. The order dated 28/11/2013 being patently illegal and without jurisdiction, findings recorded in the said orders are of no consequence. Now, the court has said when the court was examining the matter, court was in session of the matter, although there was no interim order, even in this case, there was no interim order. How can you make the matter infructuous by coming with your own evaluation and granting it to someone else? Now, my lords, the second ground, my lords, what I'm on, my lords, may kindly come to the show cause notice where they have said my bid was abnormal, my lords. That my lord would find at page number 100 and my lords, page 179, my lords, kindly. Page 179. Bulky petition, my lord, 179.
Yeah.
My lord has it, my lord, 179. It's a letter dated 31/01/24. It's addressed to the petitioner. Dear sir, madam, this is to inform you that the Financial Evaluation Committee has found your bid variation as -18% with respect to approved NIT rate amount as abnormally low in respect of package so and so. Therefore, as per this is important, my lord, to take note. Therefore, as per section 3, part 1, clause 36 of the SBD, SBD is the standard bidding document, my lords, and para 7.5.7 of the Manual of Procurement of Goods issued under the Ministry of Government of India, you are hereby requested to submit the clarification on or before 2/2/24 Friday during working hours. Now, my lords, I'll just pause here for a moment, my lords. First, it says, my lords, that my tender value is -18%. Now, the standard bidding document does not prohibit or does not quantify any, my lords, viable rates. Now, normally, my lords, lordship is aware, my lords, in some tenders, my lords, there is a viable rate. The tender document itself says, for example, I can just give an illustration, that if the estimated work value is 100 rupees, the tender document itself would say that -10% or above 10%, we won't accept it because that would be very high. So if you quote less than 90, your tender ought to be rejected. Likewise, if 10% above, it's rejected. Now, in the instant case, my lord, admittedly, there was no, my lord, rates that minus this much. They have not quantified any viable rates. That was not quantified. That's the first point. And second, my lord, the second paragraph, my lords have noted that they are relying.
Yes.
Yes. And in the second paragraph, my lords, the same page, my lords,
Mm.
my lord would see they have relied on two clauses. One, clause 36 of the standard bidding document, and second, procurement of goods 2017. So the show cause is that I have somehow violated clause 36 and the procurement of goods 2017. So since the show cause is under these two violations, purported violations, the adjudication should also be under those two grounds. The yardstick should also be the two grounds. Now, my lords would kindly,
So one is at page 179.
179.
Clarification for abnormal bid price.
Yes, yeah, abnormal
And the
bid
other
price.
one, second clause, second.
Second is some manual of procurement of goods 2017. According to them,
Which page?
well, same, my lord, same
Where?
second paragraph.
Manual of
Therefore,
procurement.
as per section
Okay,
3, R3,
yes.
and manual of procurement of goods 2017 issued by the Ministry of so and so, hereby requested. Now, thereafter, my lords, at the next page, my lords, I give my reply to that show cause. I won't trouble my lords with that. Now, thereafter, what had happened on 3/2/2024, my lords would kindly come to page 206, my lords, for a moment. After my reply, my bid was rejected. Page 206. Page 206. My bid was rejected because they say it was 18% lower than the estimated rate of the contract.
So Ministry of, so we are having somebody on the respondent side also.
Yes,
You
the
are for?
government of power.
I'm for the state, my lord,
Uh,
the power department.
Are you ready?
Yes, my lord.
My lords, page number 206.
Hmm.
So after I reply to the show cause notice, my lords, they reject my bid on the same ground, that 18% low. And my lords, like I have stated, the show cause notice was on two grounds, that violation of that clause 36
Yes.
and procurement of goods act 2017. Now, my lords would come to page 2000, page 207, my lords. I'm so sorry. The type copy, my lord, would find the type copy, page 207. The next page.
Yes, page 207.
Page 207. The evaluation committee re-evaluated the financial bids of 3 numbers of qualified firms as per directive received from the so and so to ensure fairness and transparency based on, my lord, would kindly take note, based on justified rate approved by the government of Arunachal Pradesh by memo number 18/9/2023. Now, my lords, the yardstick, what they had used, I'll read it again, my lords. 18/9, that's the memo number, my lords. Yeah, Equal, sir?
Which paragraph are you reading?
My lord, page 207, my lord, has it, annexure J,
18/9/223.
18/9/23, that paragraph, I'll just
Okay,
read it again.
All right, all right.
The-
The first paragraph.
First paragraph only, my lords. The evaluation committee
Yes, yes, I'll underline that based on justified rate.
justified it. So the yardstick which was used to see whether my bid was justified or not justified was based on a memo dated 18/9/2023. Lordship has seen it, my lords. Now, my lords would relate back to the show cause notice. Now, my lords would relate back to the show cause notice. Was I ever show cause that I have violated this memorandum? No. They had said in the show cause notice that I had violated 36 and that procurement rule 17. And that's, if my lords, if I'm charged for murder, I'll give my justification for murder. Now, my lords, it's a different memo altogether. I was never show cause that I had violated 18/9/2023. Now, one more aspect, my lords. Lordship would take note, my lords. What is this 18/9/2023? Lordship, my lords, the date of issuance of the NIT, my lord has it, my lords. It's 28/7/2023.
Hmm.
28/7/2023. So 28th of July, 2023, the tender was issued. Now this memo,
28/7/23.
23. Now this memo, what they're relying, has been issued on
After.
September, 18th of September 2023. Now, my lord, see the illegality. First, it was not part of the standard bidding document. None of the contractors were made aware that there is a quantified justifiable rate. That if you quote 15 above, 15 less, whatever, it was not there. Secondly, my lords, they rely on an office memorandum which was issued pursuant to the issuance of the tender itself.
All right.
That is one point. And second, my lords, well, let us examine the applicability of this office memorandum, my lords, 18/9/2023. So how do we examine, my lord? That has to go back to the standard bidding documents. My lord would kindly come to Code Assessment Clause 7. Page. My lord would directly come to page 70 of the standard bidding document, my lord.
Page
70. I'm referring to a part of the standard bidding document, my lords. I'm on the legality of the office memorandum now, whether
page 70.
70. My lord has it, my lord?
Yes.
It's clause 7.
Clause 7. Yes.
Addenda, corrigendum, amendment of bidding document. At any time prior to the deadline for submission of bids, the employer may amend the bidding document by issuing addenda, corrigendum, amendment, addendum, amendment will be in writing
Yes,
and
yes.
an
I
appearance.
got your point. They should.
So if
issue
they
a
wanted to
corrigendum.
that justification, they should have brought it by way of a corrigendum when? Before the submission date. That was not done because I'll come to the memorandum directly. Memorandum is page 192, my lords. My lords, just check the memorandum, whether it's a corrigenda or an addenda, my lords.
Page, which page?
192, my lords.
192.
192.
Yes.
Yes, 192, my lords.
Mm.
18th of September 23.
Mm.
My lord, I won't trouble my lords with the
Yes,
entire,
yes.
but it is not a memorandum, it is not an addenda or corrigendum to the tender, my lords. That is an admitted fact, my lords. There's no denying that, my lords. It's a common memorandum for the government of Arunachal Pradesh. Now, this is on the legality of the office memorandum. I have already, my lords, pointed out that first ground that the office memorandum is not applicable because it was issued pursuant to the tender. Second, my lords, if it had to be applied, it ought to have been done in terms of clause 7, page 92. And coming to the third point, my lords. Now, my lord, yes, my lords. Now, my lords, one more aspect, my lords, to show the mala fide in action, my lords. My lords would come to the evaluation, my lord. The first evaluation, page 207 for a moment, my lords.
Yes, page 207.
207. My lord would see in 207, they have recommended number 1, my lords. My lords would just read number 1. Messrs TNT Projects Limited has quoted 1.26 above the minimum justified rate and minus so and so below the maximum justified rate, and the firm has quoted 5.19 above the NIT amount. Deviation in percentage so and so unbalanced is enclosed, which shows more justified and falls within the range of justified rate. So as per this evaluation, they say the person who has quoted 8 crores above the justified rate and around 10 crores more than the petitioner, he's the
I got your point, yes.
he should be recommended.
Hmm.
Now, this is the first evaluation. Now, what happens thereafter, my lord? Very turn of events is very strange, my lord. My lord, come to page 217 for a moment. They again reevaluate.
270.
217, my lord, 217. The relevant portion, my lords would find at page 221. The pages are in landscape, my lords.
221?
Yes, yes. 221. Type copies there, my lord.
Yes.
My lord has it, my lord?
Yes.
Yes. Okay.
Yes, I got it.
The type copy, my lord.
Type copy.
Type
Yes,
copy.
that copy.
221.
Hmm.
Here, my lords would come to point number 3. Messrs DNG Construction has quoted 18% below the minimum justified rate. So and so, so and so. Last line, I won't trouble your lordship. Messrs DNG Construction as the most advantageous bid.
Page 221.
221. My lords, like this, my lords. It's a type copy.
Or 221A.
Must be A. I'm very sorry, my lords.
No problem. Yes, 221A. Point number 3.
Point number 3. Now, malafide is something, my lord, it has to be seen from the attending facts and circumstances. At first, they say that the person who has quoted 8 crores more than the ST, he is the bidder who should be given the contract. But thereafter, they again changed their stand, my lord. This time at paragraph 3, Messrs DNG Construction, he's like me, my lord. He has quoted only 1 crore above me. So his bid is also 18%, some 17 or 18% lower. So and so, he is the most advantageous bid. Now, they changed their stand. Now they say that the respondent number 6 is the most advantageous bid. Before that, they say 7 is the most advantageous bid. Now, this has only been done to somehow oust the petitioner and, my lords, to cater to their blue-eyed boys, my lords. And thereafter, lastly, my lords, the final, my lords would come to page 225, where retendering has been ordered, which is also under challenge, my lords. My lord would see, this is to the superintending engineer who has issued the tender, Government of Arunachal Pradesh, approval of so-and-so, with reference to your letter dated so-and-so under the reference mentioned above, wherein reviewed e-tender opening and evaluation committee's proceedings regarding Daporijo package are submitted for approval. In this regard, it is you that the government has noted various discrepancies in handling of this case, indicating an unprofessional approach. Consequently, it has been decided to initiate fresh tender process for the aforementioned package. Although I have challenged it, but this shows the conduct of the superintendent engineer, my lords. Now, my lords, logically, my lords, I am a tenderer who has quoted some 10.
Then I understand.
Yes. So they are not awarding the work to me, and they come up with justification rates and all, which was not part of the tender document at all. Now they rely on a memorandum, my lords, memorandum. So as on date, my lords, what I pray, my lords,
Stay,
it'll
you
be-
want to stay?
No, I don't want to stay also. I'm just praying, my lord, that status quo as on date may be maintained, notice may be issued, lordship would give us a short date so that they can reply, and thereafter, my lord, matter can be disposed of.
Status quo as on date may be issued.
Yes.
All right.
That is the only prayer, my lords, and I'm not trying to, my lord, stall the tender process, my lord. I'm
Yeah.
only on justice, my lord.
Yes,
A short
because
date.
this is a development project.
Yes, I'm not trying to stall it at all. So that is my humble submission, my lord.
You have a point.
Yes.
Or else
I'm very
I've
grateful,
seen your point.
subject to what my learned friend.
May I please?
Yes.
My lord, the first ground that he, despite being the L1, his bid was not accepted,
Yes.
rejected.
Hmm.
That was pursuant to a memorandum where the justified rate has been prescribed by
But
the.
that memorandum is dated later than the
That-
tender.
Exactly, my lord. That is the subject matter of the first writ petition where no stay was granted. That was urged in the first writ petition itself.
Yes, yes.
No stay was granted
stay
because if required, I can elaborate on that point also. But since that was some subject matter of the first writ petition where no stay is granted, I don't want to argue on that. If required, I can argue on that point also because justified rate has been prescribed. Just quoting the lowest rate will not suffice to be awarded the work because there has to be some workable rates. It is a technical point raised by the petitioner that this was later on prescribed, not, but from the SBD itself, there is a provision to find out what are the most advantageous bid, which are the very low quoted bids, abnormally low quoted bids.
But
They-
you have not given a particular, huh?
No, no. That is there, if required from the
Quantum,
SBD.
yes.
Yes,
quantum was not given.
SBD, my lord, SBD itself.
11% or 18%.
Yes, my lord. If my lord will, just to elaborate, if my lord comes to page 87, which is part of the SBD. Page 87.
Page 87.
Yes, my lord. This is because it was the subject matter of the first writ petition, where no stay was granted, my lord.
Page 87. Where?
Yes, if my lord finds clause 36, my lord, abnormally low bids. An abnormally low bid is one where the bid price in combination with the other elements of the bid appears so low that it raises material concern with the employer as to the capability of the bidder to perform the contract for the offered bid price. Now, how do the employer determine whether this is an abnormally low bid? There is a procedure, that's why they have a committee which has already prescribed the justified rates. The committee, if my lord will kindly see,
This is what is this is a tender document?
yes, my lord, this is the
Mem-
condition of, yes,
Agreement, tender agreement,
tender document, SBD.
SBD, okay.
Yes, my lord. And it talks about clause 38 also, if my lord will say. Page 87, clause 36.1, 36.2. I'll not bother, my lord, because, and then clause 38, the most advantageous bid. This also has to be determined. It does not say that just quoting the lowest price will the tender will be directly awarded. It is the most advantageous bid that has to be found out from amongst the bidders. Now, my lord will kindly see what actually this OM, my lord, justified rate, my lord. Want to paste that? Memorandum. 192. If my lord comes to 192, my lord, the memorandum. This memorandum, my lord, what it says, upon submissions of report and recommendation by the high level technical committee constituted by so-and-so, and within the terms of reference and mandated by event number so-and-so, that is so-and-so, the following guidelines with terms and conditions are hereby laid out for adoption in the Department of Power with immediate effect for exercising in the course of tender, bid process, bid evaluation and award of contract works of project and schemes. Pre-bid so-and-so, variation clause. If my lord will come to clause 3, my lord, to avoid misuse of clause by way of wrongful invocation, thereby resulting obstruction and associated complications in the smooth implementation of the project works, the provisions of price variation clause in SBD may be done away with. Only firm bidding may be allowed. Justified bid price ranges category wise to weed out unrealistically very low and excessively high and obstructive bidding, the justified rates range of bid price of materials and works as determined for respective category-wise areas shall have to be adopted and adhered to in the bid evaluation process of tenders and the contract award thereof for execution of Department of Power as contained in the following respective annexures, my lord. There has been, my lord, 3 categories. Category 1, here 10 divisions are there because my lord knows the geographical condition of our state, my lord. The price bid will not be same. The justified rate will not be same for each and every divisions because in some towns, nearby towns, it will be okay, but in the far-flung areas, it will be higher. Accordingly, these, as per the government has formed 3 categories, my lord. Category A, which includes capital electrical division, so and so, so and so. These are where the price bid will be, justified rate will be a bit low. Then some more tougher terrains, my lord. Rupa Electrical Division, Bomdila Electrical Division. These are in the second category. The rates will, my lord, will find in the annexures, respective annexures, my lord. Category 3, my lord, will see Tawang, Kurungkume, all these areas, the tougher terrains, my lord. So, my lord, in annexure 1, the justified rate for these divisions will be low. The annexure 2, it will be a bit higher. In annexure 3, it will be a more higher, my lord. So this way, the justified rates have been prescribed by the committee. Now, this was a subject matter in the first first writ petition where no stay has been granted. Now, after that,
This is the same document.
yes, which they have.
1823, yes.
Yes, this was the subject matter in WPC 76 that there was no, this memorandum was not issued later after the issuance of tender. This was the grounds in the first writ petition. Now there was no stay order.
Yes, no.
And after that, since it's a developmental process, leaving apart the petitioner, rest bidders were bids were evaluated, whether it.
Work order has not been issued till now.
Yes, no, they wanted to find out whether there is other eligible bidders who can be awarded. Now, there was a proposal to award to 2 different firms other than the writ petitioner. But the government has taken a decision, no, since you have not followed, that this justified rate in proper way, we will go ahead with a fresh tender. We are not going to award to any of the bidders. Now, where is the public interest? Because his writ petition still survives, my lord, if he succeeds, that despite being, that is a subject matter of the earlier writ petition. Now, the public interest will be more protected if the tender process is allowed to be continued. If he also participates, now he has got that justified rate, he can quote his, other firms also can quote, whatever, my lord, they can also participate. So for today, my lord, notice may be issued, liberty may be given to the writ petitioner to participate, which shall be subject to outcome of this writ petition or the earlier writ petition.
So he has a valid point. You can participate.
I'll just give a short reply. I'll just give a short reply to what.
And then the citation.
Yes, citation. Yes.
Citation quoted by my learned friend, that will not be applicable to this tender process, my lord. Tender process has to continue. It is not, the authorities have not taken an adverse decision against him. That decision was already taken, which is a subject matter of no further adverse decision has been taken. His bid has been rejected. Now Once rejected,
One bid is rejected. Technical bid is accepted.
yes, my lord, price bid has been now rejected
Rejected.
because it's abnormally low, my lord. There is a subject matter there, my lord. No stay is granted. Now, my lord, here, my lord will have to see as a court. Now, where public interest will suffice more. In this connection, my lord, if my lord, I have the Tata Motors judgment, my lord. I'll just because he is just making a legal, trying to make out a legal point.
So this is not applicable here.
No, my lord.
Which paragraph?
Paragraph 52, I'll just take your lordship from paragraph 52, my lord. Relevant paragraphs are 48, 52, 53, and 54.
48, 52,
53 and 54.
48, 52, 53,
And
54.
54.
Hmm.
Because private interest of the writ petitioner cannot be compromised in the for the larger public interest, my lord.
Yes.
So at this stage, he will also not suffer any loss, my lord, if he is allowed to participate and his
Participate in what?
in the tender, in the fresh tender.
You are again.
Yes, we have called
floating
fresh tender. He can participate. His interest will be protected, my lord. There will be no bar for participating, and participation will in the participation in the tender will not automatically make the earlier writ petition infractions. That may be observed.
48, 52, 53, 54.
Yes, madam.
Yes,
Yes, my,
concluded.
If my lord wants to wants me to read out the judgment, my lord, I'll
Yes,
just
yes, you can read.
para 52. I'll just take my lord to para 52. Ordinary writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of the tenderer unless something very gross and palpable is pointed out. The court ordinarily should not interfere in matters relating to tender or contract. To set it note, the entire tender process at the stage when the contract is well underway would not be in public interest. Initiating a fresh tender at this stage may consume a lot of time and also loss to public exchequer to the tune of crores of rupees. The financial burden implication on public exchequer to the state may have to be met with if the court's direct issue of fresh tender notice should be done of guiding factors that the court should keep in mind. This is evident from the so and so. Now thereafter, the law relating to award of contract by the state and public sector corporations was reviewed in so and so, and it was held that the award of contract, whether by a private party or by a state, is essentially a commercial transaction. It can choose its own method to arrive at a decision, and it is free to grant any relaxation for bona fide reasons if the tender conditions permit such relaxations. It is further held that the state is its corporations, instrumentalities, and agencies have the public duty to be fair to all concerned. Even when some defect is found in the decision-making process, the court must exercise its discretion under Article 226 with great caution and should exercise it only in furtherance of public interest and not merely on the making of out of a legal point. The court should always keep the larger public interest in mind in order to decide whether its intervention is called for or not. Only when it comes to the conclusion that overwhelming public interest requires interference, the court should interfere. My lord, therefore, my lord, by protecting the writ petitioner's interest also, which is agitated in the earlier writ petition, he may be allowed to participate and make an observation that the participation in the subsequent tender will not automatically make the earlier writ petition infractions. In that way, if he even if he wins, if he wins that earlier writ petition, it is well and good for him. If he participates and if he is a lowest bidder in the subsequent tender, he again gains the benefit, my lord. So in larger interest, my lord, no stay may be granted in floating the tender.
First of
So
all, my lord,
I think,
well, I'll just give a brief
I
reply,
think-
then I'll leave it to your lordship.
you can participate.
No, my lord, it's not about participation. Now, first
Though
of all.
you are apprehending that again,
No,
you
no,
will be
not-
shut
not-
out from the
not-
process.
So insofar as what my learned friend has submitted, my lord, is public interest. Now, will it be against public interest to award the contract to me who has quoted 8 lakhs below the estimated cost, or will it be in public interest to give it to a person who's quoted 5 crores more? First of all, coming to public interest. Now, insofar as the, my lord, earlier writ petition is concerned, my learned friend has said there's the earlier writ petition, which if I win, well, you cannot unscramble a scrambled egg, my lords. Already they have initiated re-tender process to frustrate the earlier writ petition. Now coming to the point, my lord, just my lord, give me a moment, my lord. My lord, the main issue here is whether that document, that memorandum, 18/9/2023 is even applicable. Now, there has to be some semblance of law, my lords. It's not that tender process. And what my learned friend has submitted, Tata Cellular, it's like the Bible, Quran, Gita, my lords, but it just outlines the basic principles of a tender, my lords. Tata Cellular does not say that you can violate the standard bidding document and you can grant tender to anyone. Now, my lords, if they can produce it on the next day, that they had this mechanism of justifiable rates in the bidding documents, if they file it on affidavit, that it was there during the time of the tender, I don't have any case, my lord. But admittedly, he's referring to a memorandum, a state memorandum, which is prior to the issuance of the tender. Now, my lord would see very strange, man. I couldn't make it a part of the annexure, my lord.
Is it a part of the annexure?
Not, I just received it today, but I'll furnish a copy to my friends. This tender, like I said, is under the aegis of the central government, Power Department, Ministry of Power. Now, my lord, this is by the REC, Rural Electrification Department, under which this project in Arunachal Pradesh has been done. Now, the state of Arunachal Pradesh, they raise a very specific query. They wanted that there should be justifiable rates to cancel a tender. And this was the query, request of Department of Power, Arunachal Pradesh. Inclusion of provision to restrict bidders not to bid price rate below -2% and estimated project cost. This was the query which was sent to the nodal agency. Now, what was the reply, my lord? Nodal agency's reply there only, my lord. Nodal agency, the right column, the right side, my lord. Top right. In this regard, it is to state that clause 5.6.4 of CVC guidelines for procurement of works advises not to fix a normative percentage below the estimated cost, which would automatically be considered as an abnormally low bid. Now, the nodal agency who's responsible for doing these projects all over the country, they have said, don't fix rates, justifiable rates. Now, how come a government memorandum, state of government, the Arunachal Pradesh memorandum, apply to a tender which was floated before, my lords, before the memorandum? And my lords, insofar as, my lords, the why interim was not granted, in that matter, I was not appearing. My learned friend would like to just make a submission, why the interim was not granted.
Earlier, I was supposed to call for the records of the 76 of 2024, the first round of writ petition. Still, it is pending, notice has been issued. The conduct of the very state respondents can be ascertained from the proceeding itself, When the first writ petition was moved before this honorable court, they were, the same council, they made a statement before this honorable court. My lord, it is fair to make submission before your lordship. They made a statement before this honorable court saying that first recommendation has not been made in favor of, the respondent number 7. Herein, my lord. They were making the statement so as to mislead this honorable court. No recommendation has been made in favor of respondent number 7 TNT Enterprises, madam. Madam, this honorable court was of the opinions that when the recommendation is not at all made in favor of the respondent number 7, madam, stay cannot be granted. Stay cannot be granted as ultimately it is going to affect the interest of the other firms, DNG, madam. They were making statement before this noble court saying that recommendation has been made in favor of the respondent number 6, DNG Enterprises, DNG Construction, madam. They were making the statements that recommendation has been made in favor of the DNG respondent number 6, not made in favor of the respondent number 7. Because of that reason, my lord, the interim order was not considered by his lordship's Kehito Sema, my lord. Because of that reason, my lord, we have annexed a copy of the order passed by this noble court in the 76 of 2024, my lord, wherein they made a statement only because of that reason. Again, matter was sent to the superintendent engineer who had the plotted NIT and for re-evaluation. After re-evaluation, it is made in favor of the conduct of the state respondent can be ascertained. When past recommendation was made in favor of respondent number 7, when it was filed before this honorable court by the same petitioner, then they again sent the matter back to the superintendent engineer who has plotted NIT. And the NIT in re-evaluation, again another recommendations come with the recommendation in favor of the respondent number 6. Again now when the state government is, the accepting authority is not in a position to accept the recommendation after recommendation, the state respondent, again they are giving the another
Respondent number 7.
respondent number 7. Again they are saying that press NIT may be conducted, given. Subsequently, madam.
And my lord, and this thing is self-contradictory. This justification rates. My lord would see in the first evaluation, they recommended the person who had quoted above
You
the.
see, now you are relying on a document which you have not annexed, so I cannot take this into consideration.
My lord may not take that into consideration. Even then, my lord would just one point I'm trying to make here, my lord. My lord, my learned friend was urging on the justified rates that mine was abnormally low because it was 18%. But in the first evaluation, they recommended the person who was above the estimated, that is all right. Again, thereafter, they recommended the contractor whose bid was 17% low.
No, they have another document. They have a document also.
My lord.
You have many documents, but they also have a document that SBD.
Yes, yes.
SBD.
Yes, yes, that's what I'm saying. What I'm trying to make a point, my lord, here, that they are saying 18% is not justifiable, it's abnormal. That's what they're saying. In substance, 18%.
So you are not seeking status quo. You are not seeking status quo, are you?
I'm seeking status quo with regard to the retender because
You are not seeking stay.
No, I'm not seeking stay. What I pray, my lord, it's a very reasonable prayer, my lord.
Status quo to be maintained.
The status quo.
So status quo is not stay.
Status quo will amount to stalling the tendering process.
My lord,
Yes,
in
my lord.
1 week, bids can be exchanged and matter can be heard finally. That's what I'm saying because it will cause
There will
grave
be-
injustice.
There will be
If-
no disadvantage to
I'll just continue.
my learned
If
friend.
my lords, the retender is the tender is issued, that makes my matter infructuous. And my lords, keep in mind, it's not that I have quoted a very high rate. I'm quoted a very less 18% below. What is the harm in it, my lords? I've quoted a rate which is the lowest bidder. They are rejecting my bid and they're selecting someone who has quoted 10 crores
You
more.
have come from Guwahati,
My lords, my lords.
so you'll be here tomorrow,
Not tomorrow, my lords.
not tomorrow.
My lords, what I pray, my lords. What I
No,
pray.
you said no pleadings can be.
Yes, in one week, my lords, pleadings can be exchanged and lordship would fix it for final hearing, so then matter can be disposed of. Till then, if he gives
My
me
lord,
any then-
once status quo is given, my lord knows, my lord, the matter will be prolonged.
I
No, my lord,
My
there
lord,
is an order by
Protecting,
my lord.
my
My lord would protect my interest as well, my lord, because
my
there is a-
suggestion is that his rights will also be protected if my lord observes that the participation in the subsequent tender will not
Well, why will I
make the-
participate? I have already been the lowest bidder.
he
After-
can still participate with the justified rate also now.
Now, if I participate, then I very
succeeds in
well
the-
withdraw the matter today, my lords.
If he
If I
succeeds in the
participate,
earlier
why have I come
petition,
to the court, my lords? I would withdraw the matter.
That is the reason I got
that will only amount to their, they are interested only to stall the
It's
process.
neither here, neither there. First they say you give it to them, give it to.
just
No, we have taken a decision now not to award it to anyone. To go for a fresh tender.
Examination, my lord. without, my lord, any there is a clause, my lord, cannot sit for the another examination, my lord. We have
Exactly.
already, my lord, the first in the examination, my lord.
I have cleared my matriculation, I have secured first
Now they are
position. Now they are saying you again appear, my lord.
No, no, no.
I am
That
that,
is-
it's not
that is
that-
going to, my lord.
My lord,
participation-
examine the matter, my lords, and what I'm praying, only a week or 10 days maximum. Till then, at least they not to go forward with the tender, my lord. That is the
My lord,
only.
that will,
A statement, that will
will,
suffice, my lord. We'll exchange pleadings and the matter may be
Because-
finally heard.
because
we
in
also
the
have a-
earlier writ petition, there was no stay.
Earlier
They-
petition
their
because they
bid
were
have
misleading
been
facts,
already
my lord.
rejected.
Misleading of the facts, my lord. As I
No, no,
told
no.
them.
Not misleading of
I
the
was
fact.
not there, of course, my lord. My learned friend.
No,
Take
no.
the lordship to them, my lord.
They-
Then in that case, my lord, 76.
My lord, we
may
won't
be called
trouble,
for, my
we
lord.
won't trouble my lord. My lord
No, no.
will examine the
Petition
matter and
76
my
may be called
prayer,
for.
lordship may take
My
it.
lord, the writ
into
petition 76 may be called.
No, no,
I like this.
how can I get into
No, my lord, that is not required. That is not required.
that arena because it is by a different judge
That is
Yes,
not
my lord.
required.
with
That is not
different
required.
point of view.
No,
How can I?
My lord,
My
our-
lord, if my lord's
my lord,
is on
our
the
challenge-
technicalities, it won't operate as a res judicata because it's a fresh cause of action. That my lord need not be worried about. It's a fresh petition. My lord has my lord's own discretion under 226, which my lords would exercise, my lords. That's my submission. My lord may examine the matter and pass necessary orders, please.
Okay, then I'll
No
pass an
status quo,
order
my lord.
now.
Let them participate, my lord.
Half I'll declare now, half in the afternoon. Pass an order now. Because if I take it with me, then again I'll have to take it back to Guwahati and how long will
that
it
will be-
take, I don't know.
First round, first round. But they are for stay from another entire proceeding. But my lord, they mislead and before this number, no, they make a matter different experience.
Please
No
correct.
recommendation is made.
Please correct your submission.
Don't
Don't say mislead. We have never misled.
Yes, my.
What we have,
In the visa record, my lord, there can be.
Yes,
record.
yes.
My second.
we have made submissions on our instructions, my lord.
Therefore, my lord, this is the instruction, wrong instruction.
No, no,
made by
no.
the responding authority. Yes, will make the
They have
responsibility before this another court. This is the conduct of the state respondent, my lord. I'm saying.
My lord, and there cannot be, I was just trying to protect their rights. Otherwise, they don't have a right to claim for awarding the award. They are abnormally low, whether they will succeed or not. That is a subject matter of the earlier writ petition. On that same foundation, my lord will never pass any stay order, my lord. Even no, my lord.
It's called the
That is-
right of parity, my lord.
Still, their foundation is that
Because of the
they are the
Indian
lowest
Constitution,
bidder.
Article 14, my lord.
No, their basic foundation in this writ petition also is that they are the lowest bidder. That
I'm
is a
not
subject
bringing
matter.
that writ petition
Yes,
into,
my lord.
into this order now. Why stay was granted or why not granted,
Yeah,
I'm not
that-
bringing it into.
On that
this.
same foundation, no stay can be granted here.
It was item number
Three, my lords.
3, no? Heard Mr. P. Mohanto,
Three more to-
learned counsel for the petitioner. Then MS Ringia Enterprises. Heard Mr. M. Kato also. M. Kato also.
Yes, yes.
Uh-huh. Not today.
Yes, my lord, I will.
Okay. P. Mohanto, it will, heard Mr. M. Kato. On behalf of the petitioner and L. Parme, SG,
N Ratan,
huh?
additional AG. N Ratan.
Additional double AG. For the respondent.
One to five.
For the respondents 1 to 5. The petitioner has filed this application under Article 226 of the Constitution of India, praying for issuance of a writ in the nature of certiorari or any other appropriate writ. setting aside the order dated 3/2/2024.
Yes, 3/2/24 and the correspondence dated 24/03/24, whereby retender was
And the correspondence.
dated 24/03/24. Page 224.
24/3/24. Whereby the bid of the petitioner was rejected and
My lord,
subsequently
yes,
the order for retender has been reissued, has been issued.
my lord, in terms of 24/03/24, the government has directed the superintending engineer to retender. It has not yet
Yes,
been
yes.
done. It has
An
not.
order for retend and pass an order for retender.
Yes.
Full stop. Reissued nahi, huh? And NIT was floated on 28/7/2023, and the present petitioner was successful in the price bid, and he was the L1 bidder. However, in the financial, also in the price bid, he was the L1 bidder, no?
I was the L1.
Was successful in the technical bid. However, full stop. Price bid, you cut out price bid, huh? Technical bid, full stop. However, the petitioner was the lowest bidder, comma, L1 in the price bid, in the financial bid, but the petitioner was disqualified and respondent number 7 was qualified. 7 or 6?
First 7, my
First,
lord.
and
First 7.
respondent number?
None has been qualified.
Huh?
None
Recommended.
has been qualified.
Recommended.
Recommended,
Sorry.
recommended.
And respondent number 6 was?
7 was recommended first, then 6. Again, they changed there.
Respondent number 7 was recommended initially by the
My lords, by re-evaluation report, which my lords would find at Annexure J, page 207.
respondent number 6 was recommended, no?
But 7 was recommended first, thereafter 6.
Or respondent number 7 was recommended, full stop. Initially, and thereafter, after re-evaluation.
Again, after the second re-evaluation, the respondent number 6 was recommended, my lords.
7 was 6 was recommended, and again after second re-evaluation, the respondent number 7 was
First re-evaluation, 7 was
second,
recommended.
respondent number
Thereafter,
6 was
thereafter second re-evaluation, 6 was. Just the respondent numbers would be different.
I'll correct it
My lords.
later. Now that I know the story, I'll correct it later.
My lords. Thereafter, my lord, they had.
It is averred by the petitioner that the petitioner had quoted rates which is 18% below the base price, whereas the respondent number 6 had quoted
17% less.
rates which is 17% below the base price, and the respondent number 7 had quoted
5% above.
rates 5% above the base price. First off, surprisingly, the petitioner was not recommended as the other 2 respondents were recommended. So they were favored.
Do I contractors on the 6 and 7?
Anti-favored.
Yes, my lord. Thereafter, my lord, when the conduct of the superintendent engineer came to the notice of the government, they said nothing doing, you cancel and retender it.
Who had, as they were being bestowed with, recommended, comma, as they were being bestowed with undue favor by the, which was the.
225, my lords.
How many, which number respondent was it?
My lord, respondent number
Undue favor?
6 and 7. First 7 was favored, then 6.
Undue favor was showered by which respondent?
The 2, respondent number 2, the superintendent engineer.
By the respondent number 2, comma, the superintending engineer. the conduct of the superintending engineer came to the notice of the higher authority,
Chief Engineer Power, my lord.
chief engineer power.
And by letter dated, my lords, 24/03/24 at page 225. The second paragraph,
Two hundred twenty-five.
his conduct was also noted, and
Chief engineer power, within bracket power, comma, CEZ, comma. Department of Power, full stop. While letter dated 24/11, no, 25/3/2024.
24/03/24, page 225.
24/3/2024, the chief engineer directed the superintendent engineer to proceed with re-tendering of the Daporijo package, ensuring strict adherence to the model code, MODEL, model code of conduct.
Also questioned his conduct also of the superintendent engineer.
Hmm.
The chief engineer has
Yeah,
said that you are very
that I just
unprofessional. Yes,
dictated.
yes. I'm so sorry, madam. I'm sorry to disturb you.
No, you'll have to help me out.
Madam.
So after this, that was the first tender, second tender.
After this, madam, we have challenges. They have not yet issued the retender. This was the direction. So this is also under challenge before my lords, madam. Retender is issued, my matter becomes infractuous. Madam.
So what you have challenged in the earlier writ petition?
Earlier writ petition, my rejection first, my tender was rejected, and these things have happened thereafter after the writ petition was filed.
It is further submitted on behalf of the petitioners that after the petitioner was not recommended, the petitioner had challenged the order
Dated 03/02/24, rejecting the petitioner's bid.
rejecting the petitioner's tender. Petitioner's bid
As abnormally low.
as unusually abnormal.
Abnormally low, they say. Madam.
This order was challenged before this court, which was true. This order was challenged before this court by the petitioner, and the petitioner had preferred writ petition, which was registered as WPC number.
76 of 24, my lords, WPC.
Thereafter, the respondent authorities so the re-evaluation.
Yes.
Thereafter, the respondent authorities proceeded with the re-evaluation of the tender, and the respondent number 6 was selected after.
Seven was selected first,
Respondent number 7 was selected
and thereafter again it was changed, my lord.
after the re-evaluation.
Again re-evaluation happened, again 6, my lord. Contrary to their own stand.
So was there any complaint or was there any order?
No complaint. They just thought, my lord, first.
It is submitted that the conduct of the
Superintending engineer.
superintending engineer is questionable as after selecting after recommending the respondent number
Seven.
7, the respondent authorities again proceeded for re-evaluation, and then the respondent number 7 was
6 was recommended, my lord.
and the respondent number 6 was recommended. And again, there was a third re-evaluation.
Two. Thereafter, my lord, this letter was there,
Okay.
that since there are discrepancies, you issue retender.
Finally, the letter dated
Letter dated 24/03/24.
24/03 24/03/24 was issued, and at present there has been no retendering process or re-evaluation.
Not as on date,
process.
they are in the process of doing it, my lord.
No retendering process or no re-evaluation process. During the re-evaluation, the decisions of the respondents were not based on reasons which renders the entire process suspicious. The petitioner has relied on the decision of this court, in Akkada Sali,
Akkada
AKADDAS, Akkada Sali versus State of Assam and others. 2014 4 GLR 3, wherein it has been observed that paragraph 15.
Paragraph 15.
I'll go now, we'll come back at 2. Relying on that decision, paragraph 15, this book. Relying on the decision, the petitioners have submitted that when the court was in session, there was re-evaluation of tender, and there were on 2 occasions. This reflects the clandestine manner in which the respondents have acted surreptitiously. All right?
Yes, ma'am.
So we'll come back at 2.
Yes. But just, Manas.
Yes, what do you want?
Just
to do?
one paragraph
There's
of
three
Doctor
more.
Associates, just one paragraph, I won't read it, madam.
No,
Say why-
I won't take.
No.
Another.
Ma'am.
I have got again this one,
Yes.
Tata Motors also.
Tata. I'm very grateful.
So we'll come back at 2.
Posted on 21st of this month was.
Automatically it will get posted, because I think I won't be able to finish all the today entire list. I won't be able to finish.
See, I have taken consent from petitioner side also.
All right. You're for the petitioner,
And for the respondent number 3 loss.
respondent number,
3 loss.
Learned Counsel, Mr.
D Lona.
For the respondent, with the consent of the other side, has prayed for adjournment, list the matter.
21 loss. Of license.
May I lordship?
Yes.
Manas, item number 42, my lord. Just now I have received the affidavit.
Won't reach. Item number 42 won't
40.
reach.
This matter may be adjourned for 3 weeks, my lord. I have just received the affidavit, my lord. So we'll file
Learned
re-judgment.
Counsel for the respondent,
Petitioner, my lord.
petitioner, Mr.
T. Kamchi,
has submitted that he has received a copy of the affidavit today,
affidavit.
and he has prayed for time to file reply.
Yes, my lord.
List the hard miss, yes or no? No. Okay, list the matter on,
After 3 weeks, my lord.
list the matter after 3 weeks.
Item number 42, my lord.
Yeah.
Much already.
My lord, since it appears the matter won't be reaching item 50, can it be taken up day after tomorrow, lordship?
Item 15.
50. Day after tomorrow, lordship.
Learned Counsel for the petitioner,
Yes.
Miss
And Duncan?
And Duncan has prayed to list the matter on
8.
After tomorrow? 8, on
8.
8/5.
Oblige.
You know, I'd like to mention item number 19 on behalf of Standing Council Tabatagum. I've taken the consent of the other.
Item number, which
Nine-
item?
19.
1919.
Yes, Your Honor. This matter may be listed at the 4 weeks, Your Honor.
Learned counsel for a respondent, petitioner.
Respondent,
I'm for the petitioner, Lordship.
You are for a petitioner.
Lords.
Learned counsel for the respondent, Mr.
I am appearing on behalf of
Learned
Tabatagum.
counsel, Mr.
Estai,
On behalf of learned counsel, Mr.
Tabatagum.
For a respondent, with the consent of the other side, has prayed for adjournment, list the matter of,
After 3 weeks, Lords.
list the matter after 3 weeks.
Lords.
Which was the item? Item number?
19,
19.
19, 19,
19.
19.
Relation.
May I please, Your Lordship? Lordship, I beg to mention item number 36, Lordship. In this matter, Lordship, in respect of respondent number 1 to 4, service still awaited, Lordship. So this matter may be come up after 3 weeks, Lordship.
Item number 36.
36, Lordship. I'm for the petitioner, Lordship.
Service report on respondent number 1 to 4.
1 to 4,
Is awaited, list the matter after 3 weeks.
3 weeks. Deeply obliged. Lordship, I'm sorry, Lordship, this, in item number 36, Lordship, one more matter, that is WPC 457 of 23, Lordship. These are the connected matter. This matter may be listed as
Along with- Okay.
Lordship.
List the matter after 3 weeks along with item WPC number.
457, Lordship.
Continue, huh?
457 of 23,
Item
Lordship.
number 36, continue. List,
Lordship.
list the matter after 3 weeks along with WPC number so and so.
Lordship. Deeply obliged.
Where were we? I forgot.
One of the submissions of the petitions
Oh,
were.
the judgment.
Yes. My submissions in short may be recorded, my lord.
I record, of course.
Yes.
In short,
Yes, in short.
you do not want that.
No, my lord, that will be included, that.
His service is almost over.
Yes.
It is submitted that when the court was in session, it is submitted that when the court was in session, the respondents in a subterfuge manner proceeded along with retendering, or what was it called? Re-evaluation.
Re-evaluation.
Re-evaluation of the same tender floated on
280723.
the petitioners have drawn the attention of this court to 2723, no?
20, the date of the
Huh?
tender,
28/7/23. To the memorandum dated 18/9/2023, which was considered to be the yardstick for the rates, huh?
Viability of rates, viability of.
For the viability of the rates vis-a-vis the base price. vis-a-vis the base price. So I'll cut it short then from here. The learned counsel, should I mention the prayer?
The prayer
Stay,
and
interim stay.
interim just status quo, my lords. And the memorandum I had submitted, the memorandum was illegal on 3 counts. That lordship may add or may not.
That I have, it is also submitted that the memorandum is illegal on 3 counts, basically. That memorandum dated 18/9/2023.
Yes,
huh?
yes.
Basically,
First, my lords, it was issued.
substantially only one count I will refer. Substantially, as the memorandum was issued after the NIT was floated.
Yes, and one more, my lord, as per the standard bidding document, it has to be by way of a corrigendum. It is not a corrigendum.
It is basically from substantially cut down, write down basically, and also as per standard bidding document within bracket SPD bracket close, a corrigendum ought to have been issued before the retendering or the re-evaluation process, all right? The learned counsel for the respondents, you cut this out, strike out this last sentence. The petitioners have prayed for an order of status quo as on
As on today, my lord, with regard to the tender.
as on today with regard to the tender. All right? With regard to the tender, so that the petitioner may not be sub judice due to the pick and choose policy of the policies of the superintending engineering. As a result of the pick and choose policies of the superintending engineering, of which department?
The electrical department,
Electrical department.
Department of Power.
Yeah. Next prayer. The learned counsel for the respondents has submitted that as per the SB it is also further submitted that which was the order that the petitioner can participate.
My lord, no, the tender they have already participated. My lord,
Huh?
my submission in short.
Yes, you have stated, no, they can still participate.
Yes, my lord. My submission is that the basic foundation of this writ petition is the rejection of their bid as substantially low is a subject matter of the earlier writ petition 76 of 2024, where there is no stay order. There is a subject matter totally different. The second stand.
We will not go to the writ petition and
Yes, my lord.
at all.
Yes, my lord, may only record my submission as that basic foundation of this writ petition is the rejection of their.
It is submitted that the basic foundation of this writ petition is the subject matter of the writ petition number
76. The rejection of their bids
76 oblique 24.
2024. The second ground is that there has been two evaluations made subsequently to favor respondent number 6 and 7.
This
However,
is not true.
However, the decision is not in favor of the, either the respondent number 6 or 7. The decision is to float retender. So the second ground taken is inconsequential because the result is retender. It is not, no tender has been awarded to either the.
It is further submitted that the retendering was not followed it is submitted that it is not true that the retendering was that subsequent two retenderings.
No, my lord, two evaluations.
Or it is further submitted that the subsequent evaluations were followed not to favor, not to bestow undue favor to the respondent number 6 or 7, but to, what was it?
my submission is that the subsequent to evolution has to favor respondent 6 or 7 has not attained any finality. The decision taken is for re-evaluation, retender.
But decision has already been taken to
For
float tender.
Retender.
To float now for retendering the earlier original tender
Yes.
floated. The earlier tender floated, that the original tender floated earlier on 28, what was it? 28/7/23.
Without favoring any party.
Without favoring any party. It is also submitted that the Learned Council for the respondents has also
Object to the prayer for status quo.
P1S
Yes, that.
has also submitted that status quo may not be granted, and he has relied, has also prayed that status quo may not be granted, no stay order passed, because this tender is on the for the
Public interest.
this tender is for the public and in the interest of the this tender is in the interest of the public. Post of the Learned Council for the respondents has relied on the decision of Honorable the Supreme Court in Tata Motors Limited versus the market, no? Red Mark. It's a long name. The Brihan Mumbai Electric Supply and Transport Undertaking within bracket BEST, bracket close and others, reported in 2023 within bracket 2023 0 AIR SC 2717, wherein it has been held at para 53 and 54.
Yes, madam. Para 53.
Para 52 and 53.
53 may be quoted. 53 and 54 may be.
Para 53 and 54. So I'm not granting status quo stay.
In that case, my lord, if my lord is not inclined to grant
No.
status quo, in that case, my lord, if I may suggest, my lord would kindly see that if the retendering is done without any order today, my matter becomes infractuous. So what I'm suggesting, my lord, my suggestion, lordship would take it into consideration. My lord, they may proceed with the tender. They want to proceed with the tender, let them proceed. The only prayer, my lords, they should not finalize the tender. They may proceed, it will take a lot of time, my lords. They'll issue tender, newspaper, everything. But they should not finalize the tender without the leave of the court. That's a reasonable prayer, my lords. Because if that order is not granted, my petition becomes infractuous the moment the retender is issued. Because
But
if,
you are free to participate.
no, because my lords, my grievance is that I ought to have been,
Because,
I ought to have been granted by
understand,
this.
I understand your
So, my
grievance.
lords, that protects my.
Because you are
Yes.
apprehending that they will.
Apprehending, and because I had given
It's
the
very
lowest,
obvious that
lowest
they,
bid. My bid is out already. My bid is out. So, my lord, that would protect our interest, my lords, and that would not prejudice anyone. Let them proceed with the tender. Let them, but not to finalize it without the leave of the court. In the meantime, my lord, lordship would say exchange pleadings and you decide the matter.
Yes, my lord.
That is reasonable.
Therefore, my lord may observe that petitioner is at liberty to participate.
Why do I need liberty? I can always participate
Yes,
if I
my lord.
waive the restriction.
And then participating in that subsequent
not
tender will not make the earlier writ petition infractions.
My lord, that is the prayer. Let them proceed with the tender, but they should not finalize the tender without the leave of the court. That is the.
I have considered the submissions at the bar with circumspection. This is indeed a case which is in the public interest for electrification of the areas in remote area, electrification of towns and villages, as well as far-flung areas even in inaccessible terrains. All right. I have also considered the submission at the bar that the retendering has been proposed, and the petitioner is at liberty to. I'm not giving any liberty, but only the submission. The petitioner is at liberty to participate in the tendering process, which will be floated through the retendering process, through the retendering process. Full stop. considering in the light of the decision of the Honorable Supreme Court this is a full bench judgment, I believe.
Yes.
So in Tata Motors versus Tata Motors Supra, I am not in the light of the decision. No, strike it out. At this juncture, considering as the public interest is also strike it out. At this juncture, I am not inclined to grant any interim stay or any order of status quo, but status quo full stop. However, the petitioner is at liberty to proceed with the however, the respondents can proceed with the re-tendering process. That proceed with the re-tender. Proceed with the re-tendering. Process.
I'll not finalize it without any.
Meanwhile, till to what extent?
No, madam, they will proceed with the tender. They will invite bids, everyone would participate, but they won't issue the work order without the leave of this court, madam, in this matter. So when it is ready, in the meantime, we'll proceed with the matter. If we succeed, we succeed. If we don't succeed, it goes. So my lord would say that they would proceed with the tender, but they would not finalize the tender without the leave of the court.
Meanwhile, the respondents are not to finalize with the tender.
Without the leave of the court.
No. Leave of the court is not required for tendering.
No, not for tendering. To declare the results without the leave of the court, they will not.
Finalizing without.
That is how it is normally.
Without submitting a status report relating to the tender process. Without submitting a status report.
Leave would be easier, my lord. It's
No,
easier for them also if without the leave of the court.
Leave cannot.
No, leave not in that sense. What I'm trying to say, they'll proceed with the tender, but to declare the results, the final results, who's the L1 who will get the work, they'll take leave to leave.
We
We
cannot
want to.
injunct a result.
No, not injunction. My lord, without they will just come and they'll say that our tender is ready and we want to declare the results. They will come.
They will submit a status report and then we will proceed.
So that lordship may say it that way also. Status report before declaring the results.
Before declaring the results, without submitting a status report. Before, this will not be results. What will be when we
Before issuing any work order, that will be
before awarding a contract.
Issuing work order, awarding contract. Yes.
Before awarding
Anything,
any
my lord.
contract.
Before awarding the contract.
Before awarding. I'm very grateful, my lord. I'm deeply obliged, my lord.
Obvious, man.
So there will be little bit of tweaking and tinkering without
Yes.
affecting
And my
any-
lord would issue notice.
without
not-
affecting any party.
Yes, madam. My lord would issue notice to the
Oh, yes, yes, of
private
course,
respondent.
of course. If you notice to the our respondent number who
6 and 7.
6 and 7, as learned counsel, Mr. AAG, no,
Yes, I will accept notice on behalf of 1 to 5.
is present on and has accepted notice on behalf of respondent number 1 to 5. No formal notice is required to be issued. However, sufficient copies to be furnished to the respondents. Sufficient copies to be furnished to the respondents.
Okay. Private respondents, my lord,
Yes,
notice
huh?
has to go. Private respondents, 6 and 7.
I have passed an order, no?
Yes, and last request, my lord, since it's tender matter, lordship would say they would expedite the matter and exchange pleadings and fix a date, my lord. Within a short date, we'll exchange pleading. Within a short date, we'll exchange pleadings and matter will be finally heard since it's a tender matter.
Okay.
Their interest would
Pleadings to
also.
be exchanged and pleadings to be exchanged within list the matter on date,
Next week, if it's possible. Or-
because you are coming from Guwahati, so
Guwahati,
give me a date.
Can I give him a date? my lord?
Meanwhile, pleadings to be exchanged and the matter will be taken up for
Disposal expeditiously.
expeditious disposal.
Very
On
grateful.
28,
Matter, and the matter will be
20.
disposed of
20,
expeditiously as.
बोल देगा 2 minutes. Deeply obliged. Deeply obliged.
Item number 7 to 11.
This is, you keep this with you. Yes,
My please, your lordship.
7 to 11. four
Yes.
items, yes.
Yes.
We start with which one?
Item number 7 is an IA
Ah.
for modification, vacation of stay order.
Vacating the interim order dated
But,
24/1/2023.
Item number 7.
It's item number 7, but this honorable court has passed an order for disposal of the petition itself, the writ petition itself. This was on
I'll take up the
20
IA on a petition.
the petition itself,
That is item number
8.
Item number 8. 7 to 11, we have it here. WPC number?
2003
Oh, yes.
03 of 23. However, Lordship, there is something that I would like to point out. This case is basically before the land acquisition notification was given, 1 year, 2 months prior to that notification, because your lordship knows very well that land acquisition process happens with the initial notification. Then prior 1 year, 2 months prior to that initial notification, it seems the deputy commissioner had passed an order saying that some rampant constructions have been going on this on the proposed land, proposed road on the right of way. So people are injuncted from doing so. So based on that order, which was passed prior to the notification, they have rejected our case, saying that your houses or whatever you have done is in violation of that order, which is in fact illegal. The deputy commissioner could not have passed such an order because before the notification is there, it is our land. Before the notification, before a land acquisition process is done. Now the deputy commissioners, the deputy commissioner has filed affidavit in opposition. They have said that based on some communication made by the army authorities, they have passed this order, this particular order. Now the army authorities have not filed affidavit. In case we proceed with the case today, we'll have to proceed in the absence of their affidavit.
Okay, okay. Who is for the army?
Mr. Kato was there also.
They have not filed affidavit.
No.
Okay, okay, okay. We'll have to call him then, or we'll have to wait for him. Because everybody has to be heard.
Yes.
Since it's been a long time, they have not filed affidavit, but it is not for my benefit actually. It is for the benefit of the court and maybe them also, because the order which they say they have passed is on the communication given to them by the army authorities.
This is relating to land acquired.
Land acquisition.
Land acquisition.
Land acquired by army.
Yes, on behalf of the army.
So they do not want to contest or why?
I don't know about that. They have not filed affidavit.
Otherwise also, my lord, there is nothing much on their behalf.
They are
because their area is a proforma defendant because only one letter only they have issued.
They are to pay the money.
They only have to pay the money.
They have to pay the
But
money.
They have not filed an affidavit.
Yes.
So any judicial-
Because the respondent number 4, the acquisition authority is one of the most important stakeholder in this among the respondent number.
No, I'm not saying it's not important. What I'm saying is the army authorities are to pay the money.
any
Since a
judicial-
year,
Mr.
they have
Kapoor,
not filed an affidavit in opposition.
They won't be submitting anything. Everybody is not present actually.
Yes.
All the parties are not present.
The council was present in the court.
He was here
I don't
actually.
know for what reason he is absent. Since a year, more than a year, the defense project has been stalled. Because of this writ petition, there is an interim order which we have against that interim order also, we have filed vacating application under 226.
You are for the government.
I'm for the respondent number 4, government.
Not a government advocate, but for the government.
Deputy Commissioner.
So why are you aggrieved?
Lordship,
Oh.
they have refused to pay compensation to us, saying that your properties, whatever you have built, they are rejected because of the violation of a certain order which was passed before the notification itself, preliminary notification, Lordship. Now they have invoked the provisions of Zoom land regulation, Lordship. And they have issued a notification also to this effect, Lordship. May see page 197.
You want to dispose it at the admission stage or should I admit it there? Both the parties are here, will fix it for hearing then.
Lordship, since they have filed this IA,
My lord, today it was supposed to be listed in the order because
it is listed in order.
on their prayer only, it was fixed for final disposal.
No, Lordship, it was decided by order dated 29/11, Lordship, may see.
File affidavit in opposition or do you have any objection? Or should we hear it and decide it?
My lord, our affidavit may not be required because the requiring authority, though, my lord, the proceeding has to be done by the state respondent. Acquisition authority ultimately is the deputy commissioner.
Okay.
Our duty is to only manage the verification.
So are you ready? Should we dispose it at the admission stage or we admit it or take it up for hearing, final hearing?
That will be better.
Final hearing.
Yes, ma'am.
Not to dispose it at
Not
the
to
admission
dispose
stage.
at this stage, my lord. If so advised, my lord, even the responsibility.
The pleadings are complete.
So far as the state respondents, deputy commissioner is concerned, only the deputy commissioner actually has filed affidavit.
My lord, kindly see,
The land department also has not filed affidavit. It's only the deputy commissioner, but it's only because he has filed the IA since there is an urgency in the situation we have.
Because I am the most important stakeholder in this acquisition proceeding. Other rest are,
So are you willing to pay or you are not willing to pay?
will
He's not
pay.
willing
If they
to
are
pay.
entitled to, will pay. On that ground, will argue.
No,
Because
they are saying we are not entitled. That's why they are not willing to pay. That's why this case.
No, I'll place my case, how you are not entitled, how you are entitled. So I will be given the chance to place my case. I have not been heard. I have just filed my affidavit in opposition. This is the first time that we are,
So are you ready?
yes,
I'll hear you then.
yeah.
So we can dispose it, but he is saying that it will be better to fix the case for hearing.
My lord, in the meantime, my lord, if so advised, my lord, will take the matter from the requiring authority.
What?
Instruction, further instruction.
Yes.
In Babu Grinya, in writ petition number 03/2023.
From Axis Decide.
My lord, there are two ground for rejection. One is, first, number one is that the structure, the houses, the construction houses and other asset, they are constructed beyond the proposed right of way. It is in the record. They are
their construction, their asset, their standing structure, whatever may be there.
So they are blocking
It
the
goes beyond
road.
the proposed right of the way.
They're blocking the road.
No,
No,
no, they are beyond the proposed right of way.
Okay. They are not, they were not, no.
Yeah, so they are not entitled.
Far away.
Yeah, far away. If they are within the proposed right of way,
that is not
to
what
that
they are
extent,
saying in the
I-
affidavit.
I'll not
I
comment.
have not seen that.
Yeah, it is there. You,
So see, you will be paying.
I-
They have no urgency. He's asking for time. Let us give him some time to go through 1 or 2 days time at least.
My problem is that because there is interim order.
Huh.
This is in fact national interest project,
Yes.
construction road.
Interim order only for 2-3 days, we will extend it. I am asking because he is asking for time. Mr. Kato is asking for time. I think he wants to go through at least the order sheets and everything.
Let the matter be taken up on Thursday then, Lordship.
Ah.
It's only of
it may be taken
3
up
days.
Monday.
Next Monday.
No, yes, next Monday, 13th.
Monday, sorry, I have difficulties. Let's do it on Thursday. This Thursday.
Next Thursday.
He's the one who needs time. I mean, short time.
They are taking time.
Because you.
I was
they have-
ready for the
Because
last,
there's an interim order in place, so.
Yes.
on their request only, we have not taken up this interim order also.
In fact,
This interim application.
No, it's not on, your Lordship may see order dated 29/11. It's not on my request.
This,
Thursday, this
this,
week.
Thursday, Lordship.
You'll be here.
yeah, I'll be here.
Learned Counsel Mr. M. Kato has paid for some time to get instructions. List the matter on Thursday. What date? 9th.
Interim order may be continued.
Interim order shall remain in force till then. 7 to 11, huh?
Here, my lord, yeah, my lord.
Yes.
Respondent
So
number
everybody's ready in this case?
1 to 1, my lord, may I? Just.
I want to find
res-
out if everybody is ready, then we will hear it and dispose it of at an same stage.
Respondent
Yes,
number
my lord, we have filed
two.
our affidavit, my lord.
Respondent number 2, 4, and 6 has to file their affidavit.
Has to file affidavit.
Yes,
Who
sir.
has to file affidavit?
Respondent number 2, 4, and 6.
Are they willing to file or they were willing to proceed without filing affidavit? The matter has come for admission. That's why I'm asking. Two,
On the
four, and
last
six.
time, on the last date also, my lord, the respondent was directed to take instruction whether they are going to file their affidavit in respect to respondent number 2, 4, and
Last
6.
date.
Yes, sir.
Interest in filing the counter affidavit in the matter or not?
Yes, sir.
So yes, two for Mr. Kato.
My lord.
Are you willing to file affidavit?
My lord, in fact, on several occasions, my lord, we informed them, my lord, the respondent number 6. But they are not responding, my lord. Subsidiary Intelligence Bureau, my lord. Subsidiary Intelligence Bureau, my lord.
Okay.
SIB, my
They're
lord.
not responding. Oh, okay. They're not
Since they are
responding.
reciting, my lord, on the, even, my lord, personally, we contacted them for conveying the message, my lord. This is the difficulty, my lord. So therefore, my lord, at this stage, my lord, since the other respondents are also not filing affidavit, my lord, in the meantime, again, I'll send the special messenger to the department for.
No, other respondents have filed. So that's not filed.
SIB has not filed.
SIB has not filed.
So this matter is, just let me check, what is this matter relating to, whether the affidavit
Regarding
is required?
compensation, my lord, admittedly, my lord, if they are entitled, my lord, the compensation will be paid, my lord.
In that case, my lord, this writ petition may be disposed of. Only directing the respondent authorities to verify and acquire the land. That is my prayer, my lord. They are in occupation of my land, my lord. I only say, you acquire, you verify the land,
You acquire and then acquire. Because since long back, or 2 decades, my lord, they are in occupation of my land, my lord, without paying any compensation. My lord. I have a very simple prayer. My lord. In that case, my lord, this writ petition may be disposed of. If they want to acquire, they can acquire. If they do not want to acquire, they cannot acquire. They won't acquire, my lord. Only direction may be issued.
Union of India is represented by
Madam,
one.
I'm for the
Ministry of
respondent,
Home Affairs,
Madam.
Director
Respondent
General
number,
Defense,
Madam, respondent number 135, they've also filed Madam affidavit. And the respondent number, Madam,
1 to 6, he will be appearing. 1 to 6.
UOI has filed affidavit, who has filed affidavit? Ministry of Home Affairs.
Yes, my lord. Ministry of Home Affairs has not filed, my lord.
No, they have
two
not.
has not filed, Madam.
Ministry of Defense has filed, my lord. And State Deputy Commissioner has filed.
Land has been acquired by whom?
Land
Defense.
are in possession of Indian Army, my lord.
Indian Army,
Yes.
Defense.
Yes, my lord. So we are only seeking, my lord, if they want to acquire, they really want to acquire land, then, my lord, as per law, they can acquire, my lord.
Tuesday next, my lord, in the meantime, my lord, again, if not, then, my lord, at least, my lord, I'll convey reasonable court regarding.
Here, my lord, may I take your lordship to affidavit of state respondent, my lord? Of respondent number. That would be much easier, my lord.
Which page?
Affidavit filed by respondent number 9, my lord.
Respond number 9.
Yes, my lord. This is for the deputy commissioner, my
Number
lord.
1, 3 and 5 have filed.
Yes, my lord. Respondent number 9.
Yes, yes.
Yes, my lord. In page 3, my lord, para 4, my lord. The deputy commissioner has admitted that SIB Intelligence Bureau
Hmm.
and the state has made the verification of land, my lord. They are in the process, my lord. Para 4, my lord. May I read, my lord?
Yes.
That with regards to the amendment made in paragraph 3, the answering respondent begs to state that in regards to all the lands, as per notification manual for land acquisition process, the requisition letter has to be sent by the requiring agency to initiate land acquisition process with minimum land requirement certificate and availability of requisite funds from the requiring body. In this regard, the land acquisition authority have not received any requirement of land. In regard to lands at Tasingla Border Intelligence Post are under occupation of subsidiary intelligence bureau, here in above SIB, have been jointly surveyed and sketch map of Tasingla BIP and Bumla BIP are prepared. Now, in this case, the draft notification under section 11 of LARR Act 2013 has, as per land acquisition manual of 2022, shall be forwarded to the government for vetting and notification. It says, my lord, respondent number 2, 4 and 6 has already taken initiative, my lord, with the deputy commissioner. It is only the respondent number 1, my lord, 3 and 5, my lord. They have to take the steps, my lord.
So the next day we will proceed without them then, if they won't appear
My lord.
without SIB. Next day we will proceed without SIB if they won't appear.
My lord, for next step, I do not have any objection, but then also I am referring for respondent number 7 and 8, who is the commissioner land and secretary land. Both of these are two personalities who do not have any role in this case. Because there is no notification, no requisition from the defense department. Unless we have any role to play, why was these two personalities should be made respondent in this?
DC, commissioner.
No, state, they are,
State,
they have been addressed as a state, my lord. State represented by the secretary, my lord. Pro forma, my lord, respondent. Deputy commissioner, my lord, cannot, my lord, represent the state, my lord.
Until a requisition letter is sent, either from the government or for the requiring agency to the government has no role to play.
My lord, that is why we are here, my lord. They are not making any requisition, my lord, but they are in possession, my lord. They are in possession, but they are not making any requisition, my lord. We are not paid any compensation, my lord.
Because of that, we are here. For a writ of mandamus, sir.
So army, I think they can acquire land.
Yes,
But
ma'am.
then they can acquire land, they can identify a plot of land and they can acquire it. But then acquiring has to be done by 2013.
Malad, even if army authority is in possession of the Malad, we don't know Malad as of now, Malad. Even if they are in possessions of the land, Malad, said land, Malad, it has to be Malad, the through proper procedure, Malad.
The 2013.
Correct, Malad. And Malad, the affidavit filed by the other respondents, it is very much clear that Malad, the land has to be Malad acquired through proper. Unless Malad, the approval in principle has to be done from the Malad, the Raksha Mantri, Malad. Even that the acquisition is not Malad. Maybe
He
it is.
just read a few lines that has been sent for vetting, that it is manual, the rules.
Yes, SIB, yes. SIB has processed, my lord. But the defense, my lord, they are not processing, my lord.
Malad, but contention of our affidavit of the respondent numbers 3, Malad, 1, 3, and 5, Malad. This is very much clear, Malad. For even acquisition, Malad, there should be Malad, the proper. Malad, that is stage, Malad, some more time may be granted, Malad, will Malad, exactly in other proceeding also, what is happening? Malad, army authorities are different, Malad, the local Malad, the military authority, same as the case, Malad. They are saying that it is within the position of the army authorities, Malad. That is called LMA, Malad, local military authority, Malad. And the defense state officer, they come with the affidavit, they know, no, this is not within the knowledge of the defense state officer. Malad. Otherwise, Malad, as per the procedure, Malad, as per the army rules, Malad, the acquisition has to be done through the defense state officer, Malad. For acquisition of any properties, Malad, it has to be routed through the Malad, through proper authorities. But maybe Malad, for some urgent reason or maybe other some external Malad,
They acquired the land.
they not acquire Malad. They are in possession of Malad.
They have possessed
Malad, how
taken
that,
the land.
now the thing is how that can be regularized and how Malad, the compensation has to be Malad, paid to the landowners appropriately is the one aspect, Malad. But the acquisition, admittedly, Malad, we have not initiated any Malad, the correspondence for acquisition of the land. So therefore, Malad, it will be best authority to say whether Malad, the deputy commissioner, I have not seen the copy of the affidavit filed by the deputy commissioner and the state respondents, Malad. But then Malad, that will be more ascertained by the Malad, the deputy commissioner and the other Malad, the authorities, whether the army is in possessions of the land as claimed by the petitioner or not.
May I, my
See,
lord?
in matters like this, see, everybody is willing to pay the compensation. But here the case is different, that the land has been taken over.
Yes, ma'am.
So for 20 years,
Yes, my lord.
2 decades, the land has been occupied there by them. He's asking whether you want to take the land, you take it,
Yes, ma'am.
or you leave it.
My lord,
Malad,
that
therefore-
assurance has been given by the defense state officer.
Malad-
Page 136, my lord. May I read? Page 136. There was a, my lord, conference, my lord. Minutes of meeting, my lord.
Page,
Headed page 136 of the writ petition. my lord. Headed by the chief minister, chief secretary, my lord. Defense state officer, my lord. Page 136, my lord.
Hmm.
Para 2, my lord. The defense state officer has assured us. my lord. Page 136, my lord. Paragraph 2, my lord. The defense state officer informed that he has been instructed to carry out DGPS survey of all army assets in Tawang district. my lord. All army assets, my lord. Now, by making that assurance, now they are taking, my lord, another plea, my lord. When they have already given us the assurance that all the measurement, verification of the land will be carried out. my lord. Now they are not carrying out the verification, my lord.
Malad, since the officer concerned is present, Malad, as per the instruction, Malad, I am told, Malad, this is in respect of Malad already acquired land, not in respect of the present the under the Ellie's position by the Malad. Malad, para 4 will be important, Malad. It was decided that there is an urgent need to carry out the re-verifications of the army land jointly by DO and the district administration, and also to avoid the discrepancies in the outcome of this verification. It has to be done adopting the same methodology which was used as at the time of the land acquisitions in the year 1987-88. That is using compass in the chain.
That is with respect to another issue, my lord. That writ petition is pending, my lord. What happened in that case, my lord?
Indian Army, my lord, they have, my lord, acquired 1450 acres, my lord. Then they started, my lord, encroachment of the, over the land, my lord. Now measurement was taken, my lord. Now by measurement of chain and compass, it was found that 1650 acres are in occupation of the Indian Army. Meaning there were, my lord, 148 acres are extra with them. My lord. That is in respect to another process. There were many complaints, my lord. This is one complaint, my lord, which was addressed in para 2, my lord. Para 4 is in respect to Chudididi block, actually. It is not mentioned here, my lord. It is actually in respect to Chudididi block, my lord. The writ
There
petition is.
definitely there'll be confusion if there are so many plots of land you have taken over. Then definitely there will be confusion.
And my lord, the great thing, my lord, they have not filed any affidavit in opposition, my lord. To my writ petition, my lord. No paragraph comment, my lord. They have admitted, my lord, to all my contention, my lord. In this case, my lord. My lord, see the affidavit of respondents, my lord. So 1, 2, my lord.
I think they
135.
have filed, I think.
135, yes, my lord. But
Affidavit.
no paragraph comment, my lord. No paragraph comment. They only took their stand, my lord. We are this and that, my lord. But no paragraph statement, my lord. Meaning they are admitting, my lord, to the statement made by me.
My lord, our stand is clear by way of filing affidavit.
There is no specific, my lord, they reach, my lord. There is no specific, my lord, paragraph comment, my lord.
Sir, in that case, let us have it on some other date. I will come with the detailed affidavit, my lord, detailed contention, my lord, detail and hearing of the matter, my lord. And my
So
lord,
when will we finally hear it?
No, my lord,
Should I admit it? This is
admitted,
affidavit.
yes.
matter may be admitted for final hearing.
But without filing affidavit in opposition, how can I admit it?
My lord, the rest, they have admitted, my lord. Rest have filed their affidavit, my lord. Only respondent number in
We will
respect of.
dispose it at the admission stage. We'll fix it for admission and we'll dispose it.
My lord.
You file affidavit or whatever instructions you want to get.
My lord.
So next week,
My lord, the instruction in respect of respondent number 6 only, my lord. Otherwise, my lord, the rest we have.
there's nothing to respond.
My lord.
Then within this week or next week?
Next week, my lord.
Next week. Okay, then on Monday,
My lord.
Learned Counsel for the Learned Counsel for the respondent number 6, Mr. M. Kato, has prayed for time to obtain instructions.
My lord. In respect of respondent number 6 only, my lord.
In respect of respondent number 6, list the matter on Monday, 13th.
13th.
List the matter on 13th.
Obliged.
Deeply obliged.
Item number 15. 15, my lord.
Same, Army.
Yes, my lord. This matter may be admitted.
Are you
and-
ready with this item number 15?
No, my
I think
lord.
you are ready, no?
I'm not ready.
This time you are not ready.
My lord. But this is a very simple case, my lord, actually.
Same
My lord,
Will you be ready by 13th?
yes, my lord.
Okay. As prayed for by Learned Counsel, Mr.
My lord, after 2 weeks, my lord.
Learned Counsel for a petitioner,
Yes.
Mr. Yes, okay.
After 2.
After 2.
Your name? Good.
BP Chow.
BP Chow.
My lord.
List the matter and with the consent of the other side, list the matter. Should I give a date or after 2 weeks?
After 2 weeks.
After 2 weeks.
Obliged.
Deeply obliged.
Yes.
Item number 17.
May I please, your lordship? Here, respondent number 2 has filed affidavit in opposition, but the remaining respondent 1, 3, and 4 is yet to file affidavit.
My lordship, we need some more time, my lordship, for respondent number 4.
Respondent number 4. Learned Government Advocate, Miss, forgot your name.
Ki Wangmu.
Has prayed for time to file affidavit in opposition for respondent number
4, my lordship.
4. List the matter on, when do you want?
After 2 weeks.
List the matter after 2 weeks.
Lordship, there is an interim order that may be continued.
Interim order shall remain in force till then.
Obliged.
My lordship,
Hmm.
Lordship, I'm for a petitioner here, lordship.
Hmm?
Lordship, this is a simple case, lordship. So this matter will be disposed today, lordship.
What about the other side?
Other side, lordship, I don't know. It's a very simple case, lordship. So just,
Tamargadi,
yes, lordship, standing council RGU, lordship.
Standing Council RGU.
Yes, Tamar Gade. It's also very small case, simple case,
Without
lordship.
hearing him, how can I dispose?
Lordship, on the last occasion also they were asked to file their affidavit in opposition, but still they haven't filed, lordship. It seems like, lordship, they are deliberately doing this, lordship. I am the sufferer, lordship.
We'll give them a last opportunity.
Okay, lordship.
Has to be given. Natural justice.
Yes, lordship, yes, that's such a.
3 weeks time to file affidavit. They did not file.
Yes, lordship, 3.
Then again,
On the last occasion, lordship.
what is your matter? You are saying that matter is very simple. What is the
Yes,
matter?
lordship, it's actually, lordship, this is, I just want a 2 weeks a direction may be issued to the respondent authorities that actually I am serving as an assistant professor in the Department of Electronic and Communication RGU, lordship. After rigorous 8 years of service, lordship, I will be eligible for selection level grade 12, lordship. Now I am in senior scale level 11, lordship. So for that, lordship, for selection lordship, for selection grade level 12, lordship, I have to go I have to undergo at least for 2 weeks training, lordship, industrial training. So, lordship, that I have asked for the respondent authorities, but they have just said that they have not approved, lordship. That is the lordship.
They have not approved.
Yes, they have not cited
2 weeks
any.
training.
Yes, or no justification. Just they have said that we are not approving you. That is the thing, lordship. So, lordship, is a very simple case, lordship.
I understand, very simple. I can
Yes,
pass an
Lord.
order, but
Yes, lordship, this can be.
without hearing, it's not correct to pass an order. And without according a last opportunity at least. And they are absent without steps, I can easily pass an order
Yes, lordship.
as they are absent.
So then, lordship, date may be fixed, lordship. Then.
Yeah. Heard Mr. G. Ginny.
Yes, lordship.
Counsel for the petitioner. The respondent is no representation from the respondent side. The respondent had taken time on 10/4/2024 to submit affidavit in opposition, but no such affidavit has been filed by the respondents. The respondents are accorded a last opportunity to place their submissions and file affidavit in opposition, failing which necessary order will be passed.
Yes, lordship.
This is the matter on after 2 weeks, 1 week.
Lordship, maybe in June first week, lordship. 3, lordship. June 3, fixed, lordship.
This is the matter on 3rd June.
Obliged, lordship.
Lordship, here I need some time to file affidavit, Lordship.
Learned Government Advocate Miss
Arbasar.
Arbasar has prayed for some time to file affidavit in opposition.
Lordship.
List the matter after 2 weeks.
3 weeks, Lordship.
3 weeks. List the matter after 3 weeks.
Already.
Item number 24. Sorry, lordship.
24.
24.
Reply not filed on behalf of respondents.
Yes, sir.
Reply not filed.
My lord, since if there is a the clause for the the appointment of the arbitrators, department must not have any the objections because ultimately it has to be resolved through the arbitration. On the last occasion, the dishonorable the quarries was where is the arbitration clause, only because of that reason order was not passed. Now, if there is arbitration clause, admittedly, this has to be resolved through arbitration, whatever the outcome may be. So therefore, for appointment of the arbitrator, we don't have any much objection.
There is an arbitration
Yes.
clause,
Lordship, page 44, kindly see, Lordship. Clause 17,
page 44.
44.
Yes,
Clause 17.
clause 17,
Yes, Lordship.
15.
It is not readable,
Yes.
illegible document.
Yes, 15. Do you have the original document?
The same one, Lordship.
All disputes between the parties of the parties to the contract, other than those to which the decisions of the CWE or any other person is by the contract expressed to be final
Page,
and binding.
you are reading page 44?
Page 44, my lord, clause 70, my lord, arbitration clause, my lord.
Page 17.
Page number 44 of writ petition, clause 70, my lord. Page number 44.
Clause 70, okay.
70,
Yes,
ma'am.
yes, please
Arbitration
read.
clause, madam.
Yes, please read, yes.
All disputes between the parties to the contract other than those for which the decisions of the CWE or any other person is by the contract expressed to be final and binding shall, after written notice by either party to the contracts to the other of them, be referred to the sole arbitration of an engineer officers to be appointed by the authority mentioned in the tender of documents, unless both the parties agree in writing, such reference shall not take place until after the completions or alleged completions of the works or the terminations of the termination or determinations of the contracts under condition number 55, 56, and 57 thereof, provided that in the event of the abandonment of the works or cancellations of the contract under condition number so and so hereof, such reference shall not be placed until alternative arrangements have been finalized by the government to get the works completed by or through any other contractors or the contractors or agency. Madam, I'll pause here for a moment, madam. Madam, this is also not as per the the latest position. This is also not correct, madam. Arbitration, if arbitrators has to be appointed, madam, at all, madam, it should be appointed independent arbitrator, madam. And we have our own, madam, the list of arbitrators. So, madam, if the appointment is made from the department, madam, definitely that will be not serve the purpose, madam. Prejudice will be definitely, but that apprehension, that prejudice may not be caused. However, that apprehension will be always there, madam. So therefore, madam, the Honorable Supreme Court has decided that even an appointment has to be made, arbitrator has to be appointed, has to be made from the independent arbitrator, not from the department or the concerned the contractors.
Both parties can agree also,
Yes, madam.
decide also to a particular arbitrator.
Yeah. Since we have on our list, so the serial number 7 and 8. If Lordship is having the copy, madam.
7 and 8.
7 and 8.
Serial number 7 and 8, madam. His Lordship, Honorable Mr. Justice H.N. Sharma and Honorable Mr. Justice C.R. Sharma, madam. Either of them, madam, the serial number 7 or 8, madam.
In which page?
Malad, it is separate, Malad, self notification. Malad, that must be available earlier occasion, Malad.
Maybe.
We have our own list of arbitrators.
Yes,
Yes,
you are agreeing to it.
yes.
Anybody?
Anyone. From 7 and
So where is your petition? Let me see your prayer. Relevant part of the petition.
Pardon, Lordship.
Relevant part of the petition. Why are aggrieved and what is, where you want to, whom do you want as an arbitrator?
In my prayer portion, Lordship,
The
page
prayer
number
portion.
17.
The petitioner is SP Singla Constructions Private Limited.
Yes.
And this is border roads.
Dear Lord.
Border roads.
My lord,
This is defense.
yes, my lord,
Border
it comes under the
defense.
defense, Ministry of Defense. My lord, the work for the construction of the project work, namely project design and construction of 200-meter span measure permanent PCS box girder type double lane bridge over river Sisiri at kilometers 945 on road Jonai Pasigat Ranagat Mevo Dambu Bomjur of National Highway 52 under.
Where are you reading?
Malad, it is in our affidavit, Malad. Must be Malad in their Malad.
Affidavit, yes. Okay.
Page 2.
So what is the dispute between you?
Malad, they have not executed the work as per the standard, Malad, as per the terms and conditions. Accordingly, we terminated, Malad. And the termination, Malad, they are claiming for the disputes, Malad, they are raising the Malad, the amount, Malad.
28 crores. 28 crores.
They raised Malad, the
Amount.
to the tune of Malad.
Loss due to delay in
Arbitration Act. Immediate arbitration.
But our contention is, Malad, of course, that will be taken into consideration in the arbitration proceeding. But
Everything
once,
is taken into consideration.
yes, ma'am.
So which is your relevant part of your reply affidavit?
Malad, our reply.
Paragraph, just mention the paragraph.
Malad, paragraph 2.
Paragraph 2.
Yes, Malad. Paragraph 2 and the paragraph 3. Only two Malad, paragraph are relevant, Malad.
Okay, please read it.
At the very outset, the answering deponent humbly begs to state that the work, namely projects design and the construction of the 200-meter spans, the measure permanent PCS box girder type double lane bridge over river Sisiri at kilometers so and so on road Jonai Pasigat Renagat Mebo Dambu Bomjur of National Highway 52 under Project Udayak in the state of Arunachal Pradesh was awarded to the contractor, namely MS
Who is the
SPC.
petitioner?
Malad. Koti so and so, this is the address number, Malad. And accepted by headquarters Udayak letter number so and so on 8th November 2008, Malad. And next letter, Malad, I'll skip. The deponents respectfully begs to state that the contract work was awarded by the headquarters Udayak on so and so date, and thereby the responsibility of the road sector has been handed over to the headquarters chief engineer project Brahma due to transfer of the executing unit so and so Brahma, and all the documents related to the contract so and so has also been handed over to the so and so by the amendment. Therefore, this honorable court may be pleased to direct the respondent petitioners to delete the name of Malad. This is not so relevant, but Malad, but some instance my submission is, Malad, since there is arbitration clause, admittedly, Malad, to make
Yes,
fair
yes,
submission.
page
Malad,
44, yes.
44, Malad.
All right, then your relevant part of your prayer, so that it will be easy for me to give the dictation.
Yes, Lord. Page 17.
Page 70, 17.
17.
And your grievance, in which page? It will be that the termination of the contract.
Yes, sir.
That is the basic grievance. So in which page? Which paragraph?
Page 6, Lord, sir.
Page 6.
6, Lord. Para H.
Para H. And this judgment Mayawati Trading Private Limited versus Pradyut Dev Burman, 2019 SCC 714, which paragraph? You have submitted a judgment also. Who submitted this judgment? Mayawati. I found it in
We
the
have not
court.
submitted. Not that is not. That must be, my lord, recent judgment wherein, my lord, it's all independent arbitrator has to be appointed.
Yes, yes.
In department, my lord, the all standard bidding documents, my lord, they used to mention this language, my lord, without having aware of that clause, my lord. So therefore, my lord, they are saying time and again, my lord, mentioning that the independent arbitrator has to be appointed from the serving employees of the department. That is not, my lord, as per the Supreme Court judgment, it is not correct.
I think para 14, I think. Not para 14, maybe part of para 13. High Court, while considering any application under section 11.4 to 11.6, is to confine itself to the examination of the existence of an arbitration agreement and leave all other preliminary issues to be decided by the arbitrator. This being the position, it is clear that the law prior to 2015 amendment that has been laid down by this court, which would have included going into whether accord and satisfaction has taken place, has now been legislatively overruled. This being the position, it is difficult to agree with the reasoning contained in the aforesaid judgment, as section 11.6a is confined to the examination of the existence of an arbitration agreement and is to be understood in a narrow sense, as it has been laid down in the judgment in Duro.
So therefore, my lord, from serial number, my lord, 7 or 8, my lord, either of the, my lord, the honorable justice may be appointed for sole arbitrator.
That
And
I think as it is there, you can appoint according to you have suggested.
for me, my lord, no issue, my lord, even
Yes, sir. I also know.
Agree.
Yes.
And only thing is, my lord, on the last occasion also, my lord, the consent has to be taken from the, my lord, the from appointed arbitrators.
Mm.
And one thing, my lord, one aspect is, my lord, even if appointment is made, my lord, whether their lordship will be, my lord, my lord,
Available or not.
available,
Consent has to-
plus willing to take up the, my lord, such matter.
Willing
or
to,
not.
yes, yes.
Yes. In last occasion,
I
my
think
lord,
that has to be done by you, I think,
no, my lord,
by, between the parties.
no, my lord, while if lordship this giving a directions by appointing his lordship, their lordship, my lord, then at least that consent regarding that part,
Yes,
my lord.
yes.
Last occasion, my lord, honorable Mr.
I have seen one order that
Yes, madam.
Justice
Medieval.
who was appointed and then consent was to be taken.
Correct. ma'am.
I don't have, do you have a copy of the judgment?
I don't have, my lord, on the last
I've
occasion,
seen the order.
my
I've
lord.
seen, yes.
Honorable Mr. Justice, my lord, SK Medi passed.
Yes,
such
yes,
order.
I have seen the order, but no, I think BP Kotagi was taken, not BP Kotagi, who was taken as appointed as the arbitrator, I forgot. If you have the judgment, copy of the
My lord, I
judgment.
don't remember. In the last occasion, my lord, I was the same counsel, my lord, for the appearing for the department, my lord. And in that case also, my lord, the consent has to be first taken from, my lord, while, my lord. If not, then
That
again,
order, I have seen that order.
yes, my lord.
Consent
And
was
if
taken.
not, then, my lord, it will be again sent back to this honorable court for the, my lord, the appointment of the fresh arbitrators. my
Please give me a copy of the judgment. I'll pass an order.
lord. I'll try to find out a copy,
Yes. Right now I'll pass the order. I'll wait for the copy.
my lord. I'll try
If
to
you
find
can,
out from,
You can give it to him also.
yes, ma'am.
Then
My
I'll,
lord.
accordingly, whom do you want? Anybody from here?
Anyone. Honorable Mr. Justice, H. It's
H.N. Sharma. H.N. Sharma, is he fit enough now? Will he be able to?
my lord, that is the whole reason, my lord, that the consent has to be taken first from the.
Sia Sharma? H.N. Sharma.
Sir Sharma is, my lord, yes.
Sia
junior.
Sharma, I have seen him.
Yes, ma'am.
Last time, I don't know, I've seen an order like that. Maybe Mr. Justice Sanjay Medi, maybe.
Yes, ma'am. His lordship, yes.
As you have said, Sanjay
Yes,
Medi.
yes.
I think, I was thinking,
Last,
MR Pathak, I don't know. MR Pathak or maybe Chief Justice, I don't know. I was thinking in that line. I
I'll-
forgot, but I have seen the order.
Yes, ma'am. I'll try to, my lord,
Yes,
collect a
yes.
copy.
Let's kind of copy, then
Yes, ma'am.
till then I'll dictate the order.
Yes, ma'am.
As it is agreed between both the parties, only last part of the order I have to insert.
Correct.
Yes, so if you can give me, it will be very helpful.
Wonderful.
Hard, Mr.
Elbam, Lords. Elbam.
Elbam, learned counsel for the petitioner. And Mr. M. Kato, learned counsel for the respondent number 1, 2, and 3.
And all respondents.
Our learned counsel for the respondents. The petitioner in this case is SP Singla Constructions Private Limited, and the respondents aided in this case are Border Road Organization through the Director General of Border Roads, Chief Engineer, Project Udaya, and the OC contract Border Roads Organization as respondent number 1, 2, and 3 respectively. The SP Singla Constructions Limited is a private company and is registered. Is a private company, is registered with its is a registered company with its registered offices is a private company, private limited company with its registered office at one 1006-1007, Pearls Best Height 1, A-5, Netaji Subhash Chandra Place, Pitampura, New Delhi. Stop. The respondent floated tender dated 1/4/2008, numbered as CA number. Stop. Capital CE within bracket, capital P bracket close, UDK, all capital, stroke 46 stroke 2008-2009. Within bracket, hereinafter referred to as the said tender. Bracket close. The petitioner participated in the bidding process and work order was issued.
My lord,
And work order was issued
in favor of petitioner.
to the petitioner. For an amount of rupee, for a lump sum amount of rupees 12,69,50, huh?
My lord,
Stroke rupees 12 crores 69 lakhs only. Within inverted commas, huh? Rupees 12 crores 69 lakhs only. To be performed within 24 months in terms of the intended completion date, viz. 6/12/2010. It is submitted on behalf of the petitioner that the work could not be completed by 6/12/2010. Despite the fact that the petitioner had diligently performed its obligation. Full stop. However, due to some unforeseen contingencies, the work could not be completed. It is further submitted on behalf of the petitioners that the work was completed on 15/10/2019. But the respondent unauthorizedly and illegally what is this?
Authorized representative
Ah,
lordship.
What is this? Purported no demand certificate issued.
Yes, lordship.
Declined.
Settled lordship. Amount was of 28 crore, but it was settled at 49 lakhs.
Disagreed.
Yes.
Unauthorizedly and illegally disagreed to settle
Settled.
settle the bill, the amount of rupees 49 lakhs, which are the expenses incurred for completion of the entire work. Only. Full stop. It is apt to mention at this juncture that the original amount was for rupees 28 crores.
28 crore.
Which had been raised by an amount of rupees 49 lakhs. Huh? as the dispute arose, the petitioner sought as certain dispute arose regarding the final bill, the petitioner sought reference of the disputes to arbitration as clause 17 of the GCC prescribed as clause 70 of the GCC. So what is the full form of the document? GCC. Tender document. Tender agreement. General conditions of contracts, GCC. General conditions of contracts. The petitioner by communication dated 22/8/2020 raised serious objections to the conduct of the respondent and expressly disclaimed the purported execution of the within inverted commas no demand certificate inverted commas close and a final bill within inverted commas final bill as being binding on the petitioner. Stop. In response, the respondent by communication dated 21/9/2020 and 14/10/2020, sought asked the petitioner to waive the applicability of section 12 within bracket 5 bracket close of the act so that an arbitrator may be appointed in terms of clause 70 of the GCC. Through next paragraph, through their communications, the respondents demonstrated its commitment to for resolution of the claims of the petitioner through arbitration. Full stop. The first paragraph ऐसे लिखना है, first paragraph. एकदम beginning में first paragraph number 1. The petitioner has filed his application under section 11 within bracket 6 of the Arbitration and Conciliation Act 1996 bracket close, herein after the Act of 1996 bracket close, with prayer to refer the dispute arising between the petitioner and the respondents in relation to a contract for construction of what is a For construction of,
Bridge lots.
huh?
Bridge lots.
Bridge where? For construction of a bridge?
It's Sisiri, River Sisiri.
Huh?
At River Sisiri lots.
Over the river?
Sisiri.
What is the spelling?
SISSERI. River Sisiri.
Only one bridge
Only one. National Highway 52.
at National Highway 52. Okay. This is the first paragraph, huh? Then you continue downwards. Next, now you continue from the last part. The respondents have filed an affidavit in opposition containing inter alia that the state or that the work, namely within inverted commas project design and construction of 200 M span SPA and span major permanent PCS box girder GIRDER type double lane bridge over river Siseri on the Junai Pasighat Renighat Mebo Dambuk Bomjur road of NH 52 under the project Udayak in the state of Arunachal Pradesh. Now you close the inverted commas. Was awarded to the petitioner contractor. Annexure 1 of the objection is the acceptance letter. Is the acceptance letter? Annexure 1 of your objection is the acceptance letter.
Which one? Which one, madam?
Of your objection in this petition? Annexure 1. Yes.
Madam, they are not raising any objection, madam. This is the initial award, award of the work, madam. On behalf of the second paragraph, hereby accept your tender is amended subsequently by number so and so with reference so and so to the lump sum amount of.
Is the acceptance of tender?
Madam.
Is the acceptance of tender for rupees 12,69,50, huh? So it is further contended that the responsibility of the road sector was handed over to no, this is not required. The second paragraph is not required, no? Third paragraph.
Madam.
Name of the answering dependent respondent of the PSL. It is further submitted that the responsibility of the road sector was handed over to the headquarter chief engineer within bracket P Brahman due to transfer of executing unit 1443 BCC with capital HQCE within bracket P bracket close Brahman, and all the documents related to the contract agreement Brahman, full stop. I have considered the submissions at the bar. It is submitted by the learned counsel for the. It is cumulatively submitted by the learned counsel for the petitioner and the learned counsel for the respondents that any dispute arising in relation to the tender can be referred to arbitration as per the general conditions of contracts. Clause 70 of general conditions of contracts. GCC. Within bracket GCC for lump sum contracts within bracket IAFW -2159 bracket close and item rate contracts within bracket IAFW -1779A bracket close. The clause 70 of the GCC is reproduced herein below. Clause 70, huh? Page 44 of the petition. This pink tag. Writing down clause CL 70, huh? 7070. Entire clause 70 is required.
My lord, that may not be required because there is arbitration clause. It has to be ultimately decided by the arbitrators.
No.
My lord, the only my lord, the important part is whether there is existence of arbitration clause or not. My lord, that has to be examined. My lord. If there is a my lord, the existence of the arbitration clause, my lord, then my lord, definitely my lord, that can be referred to the arbitrators.
But this is to the sole arbitration of an engineer officer to be appointed by the authority
My lord.
mentioned in the tender documents. But for his good, you are saying that the arbitrator to be appointed from the court.
My lord.
70, huh?
And my lord, that is my lord, the one judgment, my lord, this from this judgment, my lord, it is very much clear. This is
Which one?
passed by his lordship, my lord, Justice Michael on 11 March 2024. My lord, party's name is arbitration case number, my lord, of our own High Court, my lord. Arbitration case number, my
Please
lord,
give me that judgment, arbitration case number.
51 of 2023. Party's name, my lord, Barpeta Agro Infra. MS Barpeta Agro Infra versus Union of India and two others. Man. Here everything has been laid down, man, regarding appointment. Man.
And then you get the copy of the judgment.
Man.
I think it's not in the GLT maybe. You'll get it. What is the WPC number?
Arbitration case number
Oh, arbitration case number, okay.
51 of 2023. Party's name. Correct.
You get a copy of the judgment, you'll get it from the website.
In this case, Malan, so many Malan judgment has been referred of Supreme Court judgment is also
This
referred.
Mayawati judgment is also referred.
Yes, Malan.
The
Malan, I'm not sure about that one, Malan.
Ah.
However, Malan, only Malan thing is, Malan, here, in view of the reason stated above, the making of the final appointment of the members of the arbitral tribunal by the respondent is set aside. Malan, in this case, from arbitral tribunal, Malan, member was appointed. Consequently, in terms of section 11, subsection 6 of the 1996 Malan Arbitration Act, this court appoint Sri Mirin Moy Kumar Bhattacharjee, retired district and session judge, is arbitrator who will decide the disputes that has arisen between the parties. The parties shall appear before the said arbitrator within a period of 3 weeks from today. One important clause is the issue as to whether the arbitrator is handicapped by the provisions of the section 12, subsection 5 of N of the Schedule 7 schedules of the 1996 Act is left at the hand of the parties. If there is any strict,
so Minder Bhattacharjee was a retired district judge.
here only written. The sum and substance, the law is same.
So he's
If there is a
very active, but that much I know. Here, H.N. Sharma, I do not know. C.R. Sharma may be active. H.N. Sharma, I don't think so he'll be able to. Then I'll pass that order in that manner. You are willing. So your choice of arbitrator is H.N. Sharma.
Yes.
Both of you.
For me, no issue. But when I met His Lordship Justice H.N. Sharma,
He was
too old to.
he was fit and fine.
Physically, yes, maybe, but by appearance, he was.
Fit and fine. Okay. All right then. Both the parties have no objection if an arbitrator is appointed from the list of arbitrators from the list of list of arbitrators published or notified through notification number 99 dated 4th of August 2023. So H.N. Sharma, write down the name H.N. Sharma. Then remaining order I'll pass accordingly after. I have seen this order.
Yes, madam.
This order I have seen. That's why when you're saying that order was passed, this is Minmar Kumar, I have seen this order. I told you last time I have seen this order. This is the order I have seen. All right. Disposed of in terms of the above observation, petition is disposed of. This should be with this, this judgment Mayawati and this. It should be with this. (31) and 32. 31 to 33. Yes.
Your Ladyship, here the main parties haven't filed the affidavit till now. Respond number 1 to 8 or 9.
Rejoinder affidavit not yet filed.
Rejoinder is 4 hours. It's for respond number 11, but the main parties are respond number 1 to 9.
They have not filed affidavit.
No affidavit.
This is for orders, no?
Yes.
Yes, you are for respond number?
I'm for respondent number 1, 2, 3, 4, and 6, Lordship.
You'll file affidavit?
No, Lordship, the stage was to receive the rejoinder, Lordship.
Rejoinder.
Yes, Lordship.
And what about you?
Lordship, I'm for 10 to 11. 10 and 11. 10 and 11.
The last order is the matter which is not objected by. This was for, last order was for adjournment. 3 weeks to file 3 weeks time to file rejoinder.
Yes, it's for 11, but the main parties are 1 to 9. So if
They
they
are not willing to file, I think so.
okay, then maybe fix.
You are not filing affidavit.
I think, Lordship, we have already filed the affidavit.
No, we
You have
haven't.
already filed affidavit.
We haven't received till now.
They haven't received copies.
Your Lordship, we have also filed for
Yes.
in regard to respondent number 11.
Affidavits.
Yes, 11 we received.
They have not received copies of affidavits. All right, I'll read. Affidavit in opposition filed by the respondent number 1, 2, 3, 4, and 6.
Yes, Lordship, we have already filed.
We have filed in WPC number 46, Your Lordship.
Here you have filed.
46, yes, Your Lordship. And will be, that will cover for in.
By 46 AP by 2023, which can also be taken up along with this case.
The affidavit will cover the affidavit
Which-
for the
Which will also cover the case for WPC number 497.
Yes, 497 and 498.
497 by 22 and 498 by 22.
Yes.
So she hasn't received copies of your affidavits also?
Yes, 11 we
So-
received.
Huh?
For 11 we have received.
You have received?
Yes.
The learned counsel for the petitioner has submitted to file rejoinder against the affidavits. List the matter on. You give me these two cases. He has referred to, Mr. Kato has referred to. You can download it. GLT you don't have to download, but arbitration cases Mr. Kato has referred to. You download it and give it to me now. Okay. So you want a date or we can fix it after 2 weeks or 3 weeks?
Okay, Lordship, after 2 weeks.
Leave the matter after 2 weeks. Date is not necessary.
Measurement.
My lord,
Respondent number 9,
yes, respondent, I will take a fresh step, my lord.
you want to take fresh steps?
I will be allowed to take a fresh step. If, I think,
Service report on respondent, service report to respondent number 9 is awaited. The petitioner has submitted that fresh steps, that he may take fresh steps.
yes,
no?
on
Petitioner
respondent
to
number
take
9.
fresh steps to issue notice to respondent number 9. Respondent number,
Uh,
47, madam.
एकदम first में लिखो, in the beginning, learned counsel, Mr.
Odugong.
is present on behalf of the respondent. Learned counsel, Mr.
M. Dozy, my lord.
M. Dozy is present on behalf of respondent number
7, my lord.
7. All right. And what about 1 to 8? No, not
No.
appeared.
No.
Yes.
Yes.
Next.
Date may be given, my lord.
You want a date?
Yeah.
डेट एक दीजिए तो पहला वाला केस में अभी अभी जो दिया
34. Item number 34. 34.
Okay, 2 weeks, my lord.
25
Oh, yes.
20 pass 25
All right.
2005
Oh, yes.
Respondent number 1 and 2 is awaited. Service report.
Yes, your lordship.
Service report on respondent number 1 and 2 is awaited. List the matter after 2 weeks, 3 weeks,
2 weeks.
2 weeks.
Much okay. Your lordship, I'm appearing for private respondent number 5 to 17. Oh, no, 7 to 17. I need time to file affidavit in opposition.
My lord, they may be given last opportunity because we have issued notice in the month of November itself last year. Still, we haven't received any affidavit from the opposite parties.
Heard Mr.
P. Nyarus.
Learned counsel for the petitioner, comma, Miss as Miss, yes, your good name,
A. Rai.
and Miss A.
Rai.
Learned counsel for the respondent number 7 to 17.
Yes, your honor. Yes.
Respondent number 7 to 17, and is submitted for some time to file affidavit in the position. The full stop. Affidavit in last opportunity, should I give last opportunity?
No,
Will you be able to submit?
No, yeah, your lordship. Because we have appeared only twice.
Respondents to file affidavit in opposition positively, okay? Positively without fail on the next, after 2 weeks. After 2
3
weeks.
weeks may be given.
After 3 weeks. Learned counsel Ms. S. Sangeeta.
P. Sangeeta.
P. Sangeeta is present on behalf of respondent number
1 and 2.
1 and 2.
Briefly obliged.
We please, your lordship.
Hmm.
So in this matter, respondent number 4 only submitted affidavit in opposition, but respondent number 2 and 3 yet not filed.
My lordship, my lordship. We need some more time, my lordship.
Learned government advocate has prayed for some time to file affidavit in opposition. Release the matter after 2 weeks? 3 weeks. 3 weeks.
3 weeks.
And for respondent number 4.
Learned counsel Mr. is present for respondent number
4.
4. Learned counsel Mr.
Hello.
is
Udeka.
Udeka is present for respondent number 1 for the petitioner.
Yes.
Serially लिखना, petitioner आगे लिखना, बाद में respondent लिखना.
Item number 40. Of
Silo. Just another note.
Obliged.
Yeah, please.
Hmm.
Malab, step has been taken to respondent number 6 and 7, Malab. And the
Service
other,
report on respondent number 6 and 7 is awaited. List the matter on. Parties are represented. List the matter on.
after 3 weeks. Yep.
Notice unserved. Unserved notice returned back to this registry in respect of sole respondent.
In that case, your lordship, we will take fresh steps.
Office note, learned counsel, Mr.
E. Payang.
is present on behalf of the petitioner. So office note dated 13/3/2024 indicates that notice has been returned to the, that unserved notice has been returned to the registry. Petitioner to take fresh steps to issue notice to respondent, to the sole respondent. List the matter on. List the matter after 2 weeks.
4 weeks.
4 weeks.
4 weeks. Deeply obliged.
Nobody's appearing. Forty-three and 44. Nobody's appearing. Service report on respondent number. Learned government advocate is present. Service report on respondent number 236. Office note dated. Office note dated 4/5/24 indicates that service report on respondent number 23567 is awaited. List the matter after 2 weeks. Yes.
May I please, Lordship?
Yes, yes.
Lordship, today we have filed, I'm appearing on behalf of petitioner.
Petitioner.
We have
Affidavit
filed
reply.
affidavit in reply filed by the petitioner to the affidavit in opposition filed by the respondent number 8. Today we have filed, Lordship.
So we'll list it for admission then. Everybody is present?
Yes, Lordship.
Learned counsel, Mr.
T. Taba.
T. Taba is present.
Lordship, I have
Comma?
submission. Lordship.
Yes, yes.
Since Lordship, the interim order is in their favor and it is a contract tender matter, a fixed date may be given.
Sure.
Also Lordship, the records may be called for.
Okay. Then we cannot proceed for admission.
No, Lordship, it's only Itanagar if it's a fixed date, Lordship, it can be brought. It's not a big,
Yes.
it's up to him,
I
of
can
course.
bring it.
Hmm?
I can bring on it.
No, let us fix for orders.
Orders, my lord.
My lord,
Records
they-
are not
last
yet-
occasion also-
records are not yet called for.
No, Lordship, it can be taken up on admission even if records are called for. There shouldn't be a, in my humble submission, a different date for that, Lordship. If they're able to bring, if not, it's a different thing.
So let us call for the records and after that we'll fix for admission.
Yes,
My lord,
Lordship.
actually, I think in this case, reports have been called. I have the original reports with me. my lord.
We do not have the records. At least this.
the record-
call list is
Report
not
is
showing.
with me, my lord, as a standing council. Standing council, my lord. I'm the standing council RD.
Okay, you have the records?
Yes, my lord. Original reports I have. I have, my lord. I have in the position.
Then we'll fix for admission. Learned counsel, Mr.
T. Taba.
T. Taba is present on behalf of the petitioner. This is a writ petition, no?
Yes, Lordship.
45, Article 45.
Article
Item 45, yes. Item 45, yes. Then learned counsel, Mr. Yes, your good name
B feature, my lord.
for respondent number. How many respondents? Standing counsel for
Rural development.
rural and development.
Respond number 2 to 7.
comma, respondent number 2 to 7, and
I'm for 8, private respondent 8.
learned counsel Miss
And Duncan?
N again for respondent number 8. What about respondent number 1? Okay.
Secretary, madam. Chief Secretary.
Learned government advocate is present for respondent number 1. List, the petitioner has filed affidavit in reply. The matter is list the matter for admission.
And in the meantime, my lord, if they want to file affidavit in reply to my affidavit.
They have
my lord.
filed,
No, not filed.
We have filed
filed,
affidavit.
filed.
We'll file.
They have filed.
Today we have filed
Ah.
affidavit in reply
Copies of-
against.
You'll get the copies. Copies
On,
to be
on
furnished-
20, Lordship?
Huh?
Yes,
On
that is-
20
Copies to be furnished to the copies of the affidavit in reply to be furnished to the respondents. List the matter on 25.
Yes.
Interim order shall remain in force till then.
Yes, lots.
On which date?
25,
Yes.
2005.
Yes,
You have
Lord.
suggested the date.
No, no, I said on which date the records would be placed. That can be
Original
done.
reports.
Original records.
Yeah.
The standing council has received the original records, original case records. List them, list the matter for admission on the day you'll place it.
Yes.
On 2005. All right?
Okay.
2005 is fine for everybody?
Yes.
Yes, 2005.
With records, my lord.
Yes,
With original report.
with records.
Okay.
I'll tweak the order, correct it later.
Yes, ma'am.
Item number 46.
46 also, my lord. 46, my lord, actually, they do not have any lockup, my lord. This writ petition is liable to be dismissed, my lord.
No locus standi.
Yes, my lord. For why, my lord? This matter may be disposed of.
Lordship, here also we have filed, today we have filed reply.
Affidavit in.
Yes, Lordship. Same
Okay.
order, yes. Same connected,
Everybody,
And-
same parties,
yes, same parties,
same order, same parties.
same parties.
This is over. I don't think
Admission.
it won't be over today. On
On
20.
20, same day.
Yes, yes, 2005. I thought this won't be over today. 2 orders I have passed here. So I thought that there will be leftover, there 52 cases are fixed. And I'm so sorry, I've forgotten all your names after, maybe I have come after 6, 7 months.
Yeah.